Well, hello everyone, and welcome to Uncivil Law. So for today's story, what I want to do is walk through a legal analysis that I've been conducting on the question, can Karen Reed sue Michael Proctor and other people involved in the case for various things that they did that were improper? Karen Reed wants to sue, let's assume she wants to sue Michael Proctor, and she wants to sue some other people for various things they did, improperly searching her phone, improper, malicious prosecution. She wants to sue these people for various things. So the question is, can she sue? And the problem was she was convicted on this lesser included of the DUI. And so the question I've been trying to figure out precisely is, what is the preclusive effect of the conviction of the DUI? Because normally, if you're convicted, you can't then turn around and sue. That's the standard answer. But I was like, well, is that the answer in this situation? Is it true here? So I've been spending some time here and there trying to figure out the answer to the question, and I'm going to walk you through a legal analysis and show you my work as we get towards the answer. All right. So a conviction on a lesser included offense, such as a simple DUI, can bar a lawsuit under 1983. So 1983 is your go-to, right? 1983 is a federal law that says a state level official acting under color of law who deprives you of rights can be liable. So you want to sue the police for the bad, 42 USC 1983 is your standard go-to. So that's why I start there, because that's pretty much your standard cause of action. And then you add in other things on top of it. You add in malicious prosecution, you add in other things. But 42 USC 1983 is usually your linchpin. So we're going to assume that she's suing under 42 USC 1983 and some other stuff. So a conviction on a lesser included offense, such as a simple DUI, can bar this lawsuit if the outcome of the lawsuit would necessarily imply the invalidity of the conviction. So that's the standard. Would her successful lawsuit, if she were successful, would it undermine the jury's verdict, or would it undermine the conviction? So that's the standard. If the 1983 lawsuit does not necessarily imply the invalidity of the conviction, the lawsuit, however, can proceed despite the existence of the conviction. So that's the short answer. This all comes back to a U.S. Supreme Court case called Heck versus Humphrey, 1994. So in Heck versus Humphrey, the plaintiff sued to recover damages for alleged unconstitutional conviction or imprisonment, or for other harm caused by actions where the unlawfulness would render the conviction or sentence invalid. So that's the thing, right? They are suing, saying, okay, I was unconstitutionally convicted, I've been unconstitutionally imprisoned, right? But if that lawsuit being successful would undermine the guilty verdict, you can't do that, right? You can't basically use 1983 as a habeas mechanism. So habeas is a way to challenge a conviction under federal law, separate and apart from that, where it's just like free me from jail, right? That's a habeas. 1983 is like, give me money. So you can't use a 1983 for a habeas purpose, right? You can't use 1983 to try to do what a habeas would do, is what they're trying to say. But it goes broader than that, right? Not only can you not use 1983 for the purposes that a habeas would, you also can't use it in any way that would undermine or challenge the conviction itself. So this rule, which is now known as the Heck Doctrine, applies to any conviction, including an offense for a lesser offense, just as it would for a simple DUI. So a DUI is, of course, no difference in the first instance than any other criminal conviction. It's a criminal conviction. So it's the same in the first instance. The key inquiry, therefore, becomes whether the judgment in 1983 would imply the invalidity of the underlying conviction. The application of Heck to lesser included offenses follows the same analysis. Would success imply the invalidity of the conviction that wasn't convicted? But if it doesn't challenge it, then you're probably much on board. Courts have consistently applied the Heck Doctrine to determine whether 1983 claims are barred by convictions. For example, in a case called Donahue versus Smith, U.S. Supreme Court 2019. The Supreme Court reaffirmed the principles previously stated in Heck, stating, emphasizing concerns with parallel litigation and conflicting judgments. The court in Heck held that in order to recover damages for allegedly unconstitutional conviction or imprisonment or anything else, or other harms caused by actions whose unlawfulness would render the sentence invalid, the plaintiff has to prove the conviction had been validated in some other way. So again, if you could get the conviction itself overturned, like if she were to appeal the criminal conviction for the DUI, and she were able to get that DUI conviction overturned, then the conviction goes away, then there is no conviction and, no problem. But we're going to assume that that's not going to happen. We're going to assume that she's not going to appeal the criminal conviction for the DUI, and we're going to assume that it remains on the books for the purposes of this discussion. We're also going to assume that she's not pardoned by the governor because it's a state level offense, and why would they? Although, maybe. I don't even know if that's possible in this state. So we're going to assume that she's not pardoned by the governor or some other state authority. If she were pardoned, then obviously that also strikes it off the books, but unless that happens, it doesn't really matter. In a case called Santoro versus Tatum, Eastern District of California, the court addressed the application of Heck to a DUI case. So here's some precedent that was on point from the Eastern District of California, or at least parallel. The court in Santoro said, as a general rule, where a 1983 action seeking monetary damages or declaratory relief alleges constitutional violations that would necessarily imply the invalidity of an underlying conviction or sentence, such a claim is not cognizable under 1983 unless the conviction or sentence had first been invalidated on appeal by habeas or through some other case. While plaintiff refers to arrest by DUI, and while plaintiff clearly appears to take issue with the charge, it was not clear whether the plaintiff had been convicted in that case, and so the court then sent it back for further analysis, trying to figure out whether or not the person had been convicted, but said if the plaintiff had been convicted and the conviction not been set aside, then the case would have been barred under that particular fact pattern. So in that particular case, the court was not clear as to whether or not the defendant was convicted, because this is a federal court, right? They're suing under 1983. It's an Eastern District of California case, and the question is whether or not they had been convicted under state law. And for some reason that was unclear because of the particularities of the case. Don't really know. So it's we can't quite figure it out. But if they've been convicted, then then that would be a bar. So we're just going with that for the moment, is basically what they said. So for example, in a case with a simple DUI, as opposed to an aggravated DUI, if a person filed a 1983 lawsuit alleging a traffic stop was conducted without reasonable suspicion, the lawsuit would be barred, right? So assume that they were charged with aggravated DUI or enhanced DUI, because DUI sometimes comes in multiple different flavors, right? Sometimes DUI comes in different degrees depending on blood alcohol level or other factors. So assume they were charged with an aggravated DUI, but they're only convicted of the simple DUI, all right? And they want to sue for being pulled over. Well, that doesn't work because they were pulled over, as part of a DUI investigation. They were convicted of DUI, so the lawsuit, for the false arrest doesn't work because it would undermine the DUI conviction just as surely as it would undermine the aggravated DUI conviction. Now, of course, not all 1983 claims are barred by existing convictions, including ones on lesser included. As I stated before, the critical inquiry is whether success in the 1983 would necessarily imply the invalidity of the conviction. So, for example, in a case called Nelson versus Jazarek, Third Circuit, 1997, the court recognized that certain 1983 claims may proceed despite an existing conviction, and they cite by comparison a case called Smithart versus Towery, Ninth Circuit, 1996. And in that case of Nelson from the Third Circuit, 1997, the court said, I think quoting actually the Ninth Circuit, so they're quoting the Ninth Circuit saying, because a successful Section 1983 action for excessive force would not necessarily imply the invalidity of the arrest or conviction, in this case for assault with deadly weapon, the Heck precedent did not preclude the excessive force claim. So you used too much force on me when you were arresting me, right? and this person was convicted of assault with a deadly weapon during a traffic stop, but the excessive force issue doesn't challenge the conviction, right? Because there was no reason to use the excessive force. So that court allowed for the excessive force claim to go forward because it wouldn't undermine the verdict of the conviction. So the key phrase, according to the court in Smithery, said that if the criminal conviction arising out of the same facts and is fundamentally inconsistent with unlawful behavior, the 1983 action must be dismissed. So the key phrase seems to be this idea of fundamentally inconsistent. Is it fundamentally a challenge? And so I'm just looking through my notes to see if there's any other cases I want to discuss here, because I did some legal research just seeing if there were other cases that I want to talk about, trying to highlight the principle. There's a case from U.S. Supreme Court again, Walsh versus Cato, 2007. The U.S. Supreme Court stating if the plaintiff is ultimately convicted and if the state's civil suit would impugn the conviction, the previous precedent of Heck would require dismissal. Otherwise, the civil action will proceed absent some other bar. So basically, yeah, again, this idea of does it impugn the conviction is the thing. A case, Muldrew versus Courtney, Western District of Arkansas, 2025. The court explained in Heck, the Supreme Court held that in order to recover damages for allegedly unconstitutional conviction or imprisonment, or for other harm caused by actions whose unlawfulness will render the conviction or sentence invalid, the 1983 plaintiff must prove the conviction or sentence had been reversed, expunged, invalidated in order to make that determination. A claim for damages bearing that relationship to the conviction or sentence that has not been invalidated has not been cognizable. So again, the issue is, does the claim for damages bear on the relationship to the conviction? Again, same sort of principle, reinforcing this principle. Another case that says the same kind of thing, Dillard versus Davis, Northern District, Texas, 2022. The rationale is that a constitutional challenge to one's conviction or sentence would sound in habeas, not tort, 1983. So again, like, you want to challenge your conviction, you can't do it through a 1983. Same exact principle. Another case, Aleem versus Ellis, Northern District, California, 2018. The Heck rule also prevents a person from bringing an action that, even if it does not directly challenge the conviction or decision, would imply the conviction or decision was invalid. So it doesn't necessarily need to even directly challenge it. It just needs to, in some way, imply, impugn, undermine, countermand, challenge the conviction. If it does any of those things, not so much. Whether these claims are barred requires a case-by-case determination rather than a per se rule. Patterson versus New York, Northern District of New York, 2020. The Heck courts directed that when a state prisoner seeks damages in 1983, the district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of conviction or sentence. If it would, the complaint must be dismissed unless the plaintiff can demonstrate the conviction had been invalidated. Like, this language should all sound the same. The courts are just all saying the same thing. I'm just trying to show you I did a lot of legal research trying to show my work. So just trying to show you these cases so that you help understand these things. So basically, the key inquiry therefore becomes not whether the conviction is for a primary offense or lesser offense, but whether success in a 1983 would necessarily imply the invalidity. If it would, or impugn it, or countermand it, or counsel against it. If it would, the 1983 is barred. If not, it might be surviving. Okay, great. So, what is the preclusive effect of the conviction? What is the preclusive effect of the conviction as it relates to Karen Reed? All right, so can she sue the prosecutor? No. Can she sue for malicious prosecution or wrongful prosecution? No, she can't. Why? Because she was convicted, right? She was convicted. So she can't sue Brennan. She can't sue Lally. She can't sue the office because for malicious or wrongful prosecution. She can't sue the police for malicious or wrongful prosecution because she was convicted of a DUI. which was there the whole time. Right? So she can't get to wrongful prosecution or malicious prosecution. I think that cause of action is gone. However, she might be able to get to Proctor because of Proctor for searching her phone improperly. Although, because he searched the phone at a time when he didn't have a search warrant. So he might be able to search that. Although I think he later got a search warrant, and so that might be a bar there too. So he might be able to sue Proctor in that way, for Fourth Amendment violations, essentially. Although, of course, at that point, qualified immunity issues pop into play because, of course, even though Proctor has since been dismissed from the force, he was a law enforcement officer at the time. So he would have qualified immunity because he was law enforcement at the time. His status being stripped doesn't retroactively make him not a police officer. He was a police officer at the time. So he still has qualified immunity issues. And so qualified immunity becomes challenging because you have to show a violation of your rights that's been clearly established. And for anyone who knows 1983 law, that last part becomes really tricky. Showing the clearly established part becomes a real problem. Now, that might be facilitated by some state laws relating to this. There might be state law and state law precedent that helps get you there. But, in the absence of such decisions, you have a qualified immunity problem. Also, she can't sue the state police as an entity. So she can sue Proctor, but she can't sue the Massachusetts State Police because the Massachusetts State Police is a state level entity and they have sovereign immunity. So she can't sue the prosecutor in the prosecutor's office because of the Heck Doctrine. She can't sue the Massachusetts State Police because of sovereign immunity. She can sue Proctor and other officers potentially for 1983 violations, although they have a qualified immunity issue. And, getting past all that can be problems. But that is my best legal analysis as it stands right now. So my view as it sits right now, because the question would be, if you're suing Proctor from the Heck Doctrine, the question would be, how would suing him for the Fourth Amendment violations undermine the conviction? And it wouldn't, right? Because whether or not he improperly searched the phone, right, really doesn't do anything to undermine the conviction, it seems to me. Now, I would imagine that Proctor and anyone else she would sue would cite this doctrine all day long, because I would if I were their attorneys, right? I'd cite this doctrine. But I think in the end that they would lose the issue relating to the Heck bar, because there's no reason that suing Proctor or suing any of the other individual police involved for constitutional violations would undermine the conviction for the DUI. It doesn't seem to me. So I think her lawsuit can get off the ground, and it will face challenges, to be sure, but I think it can get off the ground. So that is my view of the situation based on my legal research in trying to get to this question of can she sue or not, because it was an interesting legal question. So I did as much research as I could to try to figure out, and that's what I came up with. So that is my view of the situation. Possible, but difficult. Against Proctor. Not possible against the prosecutor, not possible against Brennan, not possible against Lally, not possible against the prosecutor's office, not possible against the state police. Possible against Proctor, maybe some other individual officers. Also not possible against the ATF agent. What's his name? Higgins? Wasn't that the ATF agent? Yeah, you can't sue him either because he's a federal officer, and you can't sue a federal officer under 1983. So you can't sue him either because he's ATF, not state police, and you can only sue state level officers under 1983. For federal officers, there's a case called Bivens, but Bivens has been massively constrained, and so I'm just going to skip to the end of the page and tell you can't sue them and just end the day. It's like I could go through a Bivens analysis, but I'm just going to save the time and be like, yeah, you can't sue them either. So not so much with that and all those things. So that's where we're sitting. on all those things. And let me see if I can answer some questions that you might have had along the way. Let's pull up chat and see what you guys are saying in chat. I'll try to answer some questions as best I can. All right, I got chat pulled up. Good luck getting money out of the unemployed man. Well, he has assets, I assume. I don't know whether or not he has a pension or not. I don't know the answer to that question. I also don't know whether or not being dismissed from the force causes him to forfeit his pension. I don't know the answer to that question. That would be a state level proceedings, but he might have assets. And, you know, you can get as much as you can get. I mean, there's that. Higgins wasn't on duty, so how would it fit? Yeah, but he was in the police office doing things in a role that looks suspiciously police-like. So I'm gonna skip to I'm gonna say that, you know, he's gonna say he was at, well, he's gonna say, yeah, well, being on duty or not is like, yeah, if he was acting as a police officer, like the fact that he wasn't like, yeah, isn't a problem, because police officers don't necessarily need to be like on duty in order for these doctrines to apply. Like if like you're just a state level officer, like you're just a normal police officer, and it's like it's not your shift, but you are now performing as a police officer, like, yeah, you kind of are a police officer all the time for like Fourth Amendment purposes. Yeah, it's like you don't stop becoming a police officer like when you're not on the clock. You're like a police officer. You don't really switch into a private capacity in that sense. So like if you break down someone's door, it'd be like, oh, I wasn't on the clock. You know, I wasn't my shift. I'm off on Sundays. And I decided to break down this guy's door. So it's not a police action. Yeah, that's not going to work. Yeah, so I think the on the clock, off the clock thing isn't going to make it. Proctor didn't qualify for pension. He might not have. I don't know the particulars of state law. So I'll pass on that issue. Why can't she sue for planting evidence in the murder scene? Well, she'd have to be able to prove that. And I don't know how you would be. Yeah. Well, first of all, you'd have to know who planted it in order to be able to sue them, which is a challenge. Like who did it would be a challenge. But yeah, I mean, I suppose you could try to sue for planting stuff at the murder scene, but I don't know that you'd be able to make your prima facie case to get past a motion to dismiss. You know, I don't know that you could get past your prima facie case to get past a motion to dismiss. You have to have enough evidence to like make it non-speculative. And I don't know what information there is, but based on the information that's currently available, I don't think you could get past a motion to dismiss, a motion for summary judgment, because you don't have anything that's, yeah, I don't think you have anything that's not speculative. The OUI was not on the indictment? Yes, it was. Yeah, it was on the indictment. That's the conceit, because it's lesser included. Yeah, it is. The OUI was on the indictment. The OUI was on the indictment the entire time. That's the conceit of a lesser included. It was there the entire time. So yes, it was there. It's, yeah, it is what it is. If she won an appeal, could she sue? Yeah, of course. If she overturns the conviction, then yes, all this analysis disappears, because now there's no conviction to impugn. So if she does decide to appeal her DUI and she's successful in that, then sure, because then there is no conviction. It just disappeared. And so then all this becomes moot. So that would obviously solve the problem. Can Brian Albert be held to any degree for not going outside? No affirmative duty by the police or a private person. So no affirmative duty. Even if he were a police officer in the jurisdiction, he has no affirmative duty to help anybody. So no, you can't sue the police for failure to help. The police can look at the police can watch you die slowly in front of them and do nothing, and you can't sue them. So yeah, that's the end of that discussion. I think she has a very viable cause of action to appeal her DUI conviction because it's unclear what DUI the jury convicted her of, because it was unclear what the time frame of the DUI is. And so the lesser included of the DUI would be the DUI relevant to the DUI manslaughter. So the DUI would be the time of the manslaughter, whatever time that would be. So Brennan suggested 1240. So 1240 for the purposes of this discussion. That would be the time of the DUI. But because that we don't know what time or what DUI she was convicted of, we don't know whether or not she was convicted of a lesser included DUI. Now, to be fair, she did somewhat invite the error because defense counsel was asked about this issue and they're like, it's up to the jury. So they somewhat invite the error. So that is a thing against her. But nevertheless, I think that she probably has a pretty solid chance of appeal nonetheless, because it's clear error despite the purported consent to the issue. Would it be worth the time, energy, and money to appeal? It depends what you're trying to do, I suppose. Yeah, I mean, would it be worth the time, energy, and money? It depends. Like, to the extent that the conviction is a barrier to a lawsuit, maybe it's worth it, but that's a whole calculation I'd have to do in terms of probabilities and expenses and everything. So that's a complicated calculation. The defense had on DUI. She was never initially charged with DUI. Once again, yes, she was. That's the legal conceit. You just have to believe me. It's a lesser included. The conceit is that she was charged with DUI the entire time. It's a lesser included of the manslaughter DUI. So yes, she was charged with DUI the entire time. That's the conceit of the lesser included. Yeah, you just have to roll with me on that one. What are you gonna get? I don't know. Money, vindication, satisfaction, pain. I don't know. If she appeals, could she run the risk of a harsher sentence? Possibly. Although you can appeal the conviction and not necessarily appeal the sentence. But yes, possible. There is some potential despite that, I think, nonetheless. So yes, you can appeal the conviction and appeal the sentence as separate issues. So you could try to appeal just the conviction and not appeal the sentence. But if the conviction were overturned, the state could retry on just the DUI. They couldn't retry on anything else, but the DUI they could retry on if they wanted to. And if she were convicted of just the DUI, then hypothetically, a judge could hypothetically sentence her to something different than they sentenced the first time. Of course, they'd have to sentence her consistent with Massachusetts state law, which does not allow for any acquitted conduct to be used as part of that sentence. So some future judge in determining the sentence would not be able to use any acquitted conduct to enhance the DUI. And I'm unaware of any other evidence that they could bring in to enhance the sentence. But hypothetically, yes. The defense added in the separate DUI. It wasn't included in it wasn't included. Yeah, but it was in the indictment the whole time. That's the thing. Yeah. It was there the entire time, just waiting to be discovered. Yeah. So the charge was not the lesser included was not presented to the jury, but the lesser included was there the entire time. The lesser included was there the whole time in trial number 1 too. The option wasn't presented to the jury, but it was there. Not to be selected by the jury, but it was there. Yeah, that's the conceit of the lesser included. If she receives income from books, how can it be protected from a civil case? Against her? It can't. If she's sued for wrongful death and that cause of action is successful, then that would be assets that she has that could be seized as part of that lawsuit. Yeah, no, the standalone DUI charge was not on the verdict sheet on trial number 1. It was not on the verdict sheet, but it was there the entire time, lurking in the background. In the same sense, incidentally, that the charge of assault has always been there. because every murder includes an assault, right? So she was also charged with assault the entire time. She was charged with assault the entire time because assault's a lesser included. So, you know, there's that. So in the exact same sense that she was charged with assault the entire time. Yeah, that's the conceit. I'm trying to understand how getting an appeal but then being able to be retried makes any sense. Well, that's pretty standard. You know, usually when you appeal, retrial is what happens. That's typically the answer. Yeah. Did the value of the civil lawsuit go down after the 3 not guilty verdicts? Oh, sure. Because the only thing that's been proven has been the DUI, right? So the DUI is proven, but nothing else has been proven. Like if she had been convicted, you know, of the murder, like that wrongful death is basically a gimme because, well, I just was found guilty, right? And so that's basically just a gimme. But she wasn't found guilty. The only thing she's been found guilty of is a DUI at an unspecified time, nonetheless, right? So in a wrongful death action against Karen Reed, you'd have to prove the wrongful death, which means, you know, you have to find experts and other evidence to make that case work. So, and that evidence, of course, has to be presented at the civil trial, right? Because that's a new case. So all that evidence has to be presented again. So you have to find experts and all that who will, you know, provide that testimony at the civil trial, and that's expensive and all the rest of it. So, you know, and good luck with all that. If she does interviews, they could use it against her in a civil suit. Sure, they can use anything she says against her. They can use any statement she makes in a suit. So to the extent that she makes statements that would incriminate her in a wrongful death, then sure, they can use those statements. Of course they can. How do I think she'll do in the civil case? Well, I think that finding experts that could testify that this accident occurred and she's responsible is going to be really hard. And assuming it's possible, incredibly expensive. So I don't know that a lawyer representing the O'Keefe's family would take that on a contingency fee, because that sounds like a bad deal to me, right? If you came to me with this case and you want me to sue for wrongful death, I'm not doing this on contingency. I'm telling you right now, I am not doing this on contingency. And also, you're paying for all my costs as we go. That's the deal, right? I will take the case. I'll take the case, but you're paying for all the expenses as we go, and you're paying for my time as we go. I am not doing this on contingency, right? Because I don't think the probability of me winning is enough for me to incur all those expenses and potentially lose. It's like, yeah, that sounds like a bad deal to me. So hourly is the way to go. Hourly plus expenses, baby, and we're paying as we go. That's the only way I'm doing it. I'll tell you what, ma'am. And you better have $500,000. I want $500,000 sitting in my trust account before I move, because I'm going to have to hire a lawyer. I'm going to have to hire experts. They're going to be expensive. And $500,000 is a very reasonable estimate. So I want to check for $500,000 sitting in my trust account before I say boo. Yeah, that's basically what that would be for me. And we'll go from there. Are we sure the O'Keefes will file? I'm pretty sure they did file. I'm pretty sure they filed long ago, and that lawsuit has been on pause this entire time. So I think they filed years ago. So yep, I'm pretty sure that already happened, and good luck with that. Incidentally, like, of course, her auto insurance, because the allegation, of course, is that she hit him with the car, right? So her auto insurance is implicated in this. And so I don't know what her policy limits are, so maybe the auto insurance company's like, we'll settle for policy limits. And depending on what those is, if I'm the O'Keefes, I'd probably take it and run. You know, if she has particularly high policy limits, I'll take it and run, ma'am. That'd be what that'd be my recommendation. Can she sue Proctor for releasing her medical condition to her friends? No, I don't think so, because he's not a covered person under HIPAA. And so the question, well, there is an invasion of privacy tort, I suppose. Invasion of private facts. There might be an invasion of private facts tort in there somewhere. Maybe to the extent that you can say that he released medical data, possibly. HIPAA doesn't work, but a standard like invasion of privacy tort might. Good to see you, by the way, Defense Diaries. How are you guys doing today? Yeah, the cost for the number of depots that would have to be conducted would be astronomical. That too, you're not wrong, right? Because everyone gets deposed all over again. We're going to depose all these people. Yeah, the deposition costs alone are going to be astronomical. Yeah, you're not wrong. Red guy 123443214 for $5 says a hypothetical Bev didn't answer of the jury hanging on a lesser. What if they insistently asked the question? Well, they didn't, so who cares? Let's just deal with the facts as they exist. Who cares? You know? Can Karen go after the aunties now for defamation? Almost certainly not, no. Because defamation, if you have the opinion that Karen Reed is a murderer, you're allowed to have that opinion, right? There's a difference between saying someone's a murderer and saying someone's a convicted murderer. So as long as you're basing that opinion based on publicly disclosed information, right? And then you're just entitled to an opinion and you're just an idiot, right? Because you can have any opinion about the evidence that you want, despite you being a moron. So as long as you are not claiming to have some private facts or private knowledge or secret information, as long as you're not claiming to have secret special facts that only you know about, right? If you're just saying, well, based on the publicly disclosed information, I think she's a murderer. Yeah, that's an opinion. You're entitled to an opinion. Opinions can't be wrong. Lol. Opinions can't be wrong, or at least you can't sue over them. So all the antis who somehow believe Karen Reed is still a murderer, they're entitled to their stupid opinion and no defamation for you. Who cares? The people want to learn about the law. I suppose that's fair. Yeah. All right. So what was your question again for $5? I'm sorry. That's fair. So the hypothetical Bev didn't answer of the jury hanging on a letter. What if they insisted on saying we're hanging on a lesser? What do we do? Yeah. So if the jury had phrased the question the right way, as less of a hypothetical, if they had said something like, we have verdicts as to count 1, count 3, but are hung as to count 2. What do you want us to do? If they had said something like that, then the judge would have had to decide whether or not to ask for partial verdicts or not, which she could do, and then also send the jury back. So she has 3 options at that point, basically. Well, let me make sure, because I have to count my options and see what she could do. So if the jury said, we have verdicts as to count 1, count 3, but are undecided as to count 2, what do you want us to do? The rules allow for her to ask for partial verdicts, but they don't require it. So she has 3 options, basically. She could say all or nothing, keep deliberating until you have a verdict as to every count, all or nothing. That would be a valid option. She could say, okay, come back with the verdicts you have. I will read them into the record, whether they're guilty or not. And she won't tell the jury this, but implicitly, whether guilty or not, I will read them into the record, and they will just be verdicts. And at that point, she can do one of 2 things. She can either send the jury back to continue deliberating only on count 2, so she can receive the verdicts as to count 1 and count 3, be like, okay, those are your verdicts as to count 1 and count 3. Those are gone now, but I'm still sending you back to debate verdict 2, try harder. let me know, get back to me. Or she could say, well, mistrial as to count 2, and you can bring it back at a separate time if you want. So those are her options. That's what she could have done. And, but of course we didn't have any of those things happen. So yeah. Rogue said, interview jurors said they were still deliberating manslaughter itself the day the verdict came out. Yeah. I mean, see there, it is what it is, right? I mean, yeah, I'm not 100% surprised. I'm glad they came out the right way in the end, but yeah, and maybe those would be interesting to watch. So if you have copies of those new juror statements, we can watch them during this stream because that would be fun. So provide it on Discord, please, because I don't accept links in the chat. Although maybe I should. Maybe I should allow links in the chat. What do you think, mods? Should I allow for links in the chat? I always thought it was kind of like a bad idea because people might click them and they might be nefarious links and stuff like that, but maybe that's not my problem. Should I allow for links in the chat? It's just a setting I changed on the back end. Should I allow for it? I don't know. At the moment, they're not allowed, so you can provide it on Discord. How much would taking a case to trial cost the O'Keefes? Oh, like, yeah, as I said, like $500,000 as a reasonable starting place. So it's like, I want $500,000 in my trust account before we blink, right? $500,000 is a very reasonable estimate. Given the depositions and experts and everything else, yeah, $500,000 sounds probably good. Would their lawyers work for free? Who, the O'Keefe's lawyers? Hell no, I wouldn't. They might work on contingency, but that sounds like a bad deal to me. Yeah, no links. Yeah, that sounds like a bad plan. Yeah, no links in chat. Yeah, this is why I didn't allow them in the first place, because it's like you never know what that's a link to. You never, yeah, I don't want to allow links. It sounded like a bad idea. Mods can. Yeah, I think mods can post links, but regular users can't. Because mods are special. Can you sue the state for libel? In principle, I suppose you could, but what would the libel be? What libel have they committed? So maybe in principle, but like what libel would there be? Yeah. You can sue them for anything, but like, what is the basis in fact for that? In theory, what could Karen Reed actually have a decent shot in terms of a civil suit? Practically, I don't really think Karen Reed has a good suit against anybody, in my best judgment. Yeah, I don't really think she has a good suit against anyone. Him searching the phone when he didn't have a warrant is bad, but he got a warrant at a later time, and that probably ratifies the conduct. Because what is the harm? Because it's like, well, I would have been able to search the phone eventually anyway. So what difference does it make, right? So the harm would be for the illegal search, but it would have been legal later. So what's the difference? So yeah, that's a problem. The text messages to the friends, I don't think it really gets you anywhere. Yeah, I don't think she really has a good cause of action against anybody. But I was trying to answer the hypothetical question, like, can she do it? Right? This whole thing has been a bit of a legal academic exercise. Like, because this question, like, can she sue? Or what is the barrier from the conviction? Like, what is the barrier to from the conviction to the lawsuit? Was been a question I've been struggling with. It's like, okay, I think I finally have an answer. I think I finally have the answer. I think the conviction is not a barrier to the lawsuit against Proctor. There are other barriers to the lawsuit against Proctor. Qualified immunity being obvious. Somehow, if we get past that, how do we get to damages? Yeah, I don't think she really has a good cause of action against anybody. I don't see it. That isn't to say, incidentally, that if she sued people, they wouldn't settle for some sort of nuisance value anyway, or they wouldn't settle, to try to appease her in some sense. So they might settle despite the lack of there being a good cause of action because, they want to say, we recognize that we did wrong. And like if they settled for $100,000, right? It's like, we'll pay you $100,000 so that we can go forward with our PR. We won't tell anyone, by the way, how much we settled for. We're going to keep that secret. But, we'll settle for $100,000 so we can go forward and say, look at us. We're good people. We recognized our wrong. We've paid for our wrongs. We're good people. They might do that. They might do it for PR reasons rather than legal reasons. I could see that. Yeah. Couldn't she sue Good Samaritan Hospital and the nurse that told Peggy O'Keefe that Karen was there on a mental hold? I don't know. Under HIPAA, the nurse told Peggy O'Keefe that Karen was there on a mental hold. Does that violate HIPAA? I don't know. Maybe it does. We could go dig into HIPAA, figure out exactly what that is, but it's interesting, right? Because it's a nurse, it's a hospital. I don't know the degree to which the fact that they're on a mental hold somehow augments that or changes that in some way. Because she's not there for a purely private reason. She's there sort of at the government's request. So I don't know the degree to which that augments or changes the HIPAA analysis. But interesting question. The remedy for illegal search is suppression, not damages. You can do both. You can do damages as well. Suppression is a typical remedy, but you can sue for damages too. Yeah, there's been cases like that. Victor Immature for 5 pounds says, ironic that it was John O'Keefe who got in the car knowing she was drunk, let her drive. Kind of didn't look good for Canton PD. Brian Alberts doesn't have homeowner insurance. It's unclear what liability the homeowner has at all based on the fact pattern, right? Because there's a dead body on my lawn, but how does the homeowner have any liability for that is unclear. Maybe there's something there, but it's not immediately obvious. It's not immediately obvious that it's like, well, how am I suing the homeowner? It's like, what did they do? What did they do? Right? So what am I suing them for? Yeah. Slip and fall? They slipped and fell on my wet grass? Yeah, I don't think so, man. I don't know about that. Emotional distress? By whom? Karen against Proctor for like telling the friends? Does she have distress? And does she have any physical harm as a result of that distress? So if she wants to sue for negligent infliction of emotional distress, she has to show some kind of physical harm. If she wants to show intentional infliction of emotional distress, well, that's even more unclear. Yeah. There are 2 in Discord? Excellent. It's a violation of HIPAA? It might be HIPAA. HIPAA's complicated. HIPAA doesn't do as much as people think it does, but that's okay. And also whether or not that's a privacy invasion tort would also be an interesting question as well. Well, I don't want to dig into the finer points of HIPAA right now because that just sounds like a bad exercise of time. But we'll watch the jury interviews. How do I feel about the test AJ did at 34 Fairview with the garage picks and yelling? I don't really have any strong opinion about any of those things. I'm not sure the garage picks really depict anything, to be honest. I'm not sure they really depict anything in and of themselves. So, yeah. Will they address the dark hole I don't know if they're going to address the black hole. No one addresses the black hole. It's very unfair. No one ever addresses the black hole. Civil practitioners do not file a suit for the principle of the thing. A judgment for $1 million a defendant has no money to speak of isn't worth the paper it's written on. That's facts too. That's fair. So what are his assets for potential damages is a fair thing. Also, incidentally, why I'm not doing this on contingency. Another reason I'm not doing this on contingency is like, first of all, I'm not sure that we can win. Second of all, if we can, I'm not sure I can get paid. So another reason why I'm not doing this on contingency. If you want me to represent, if the O'Keefes want me to represent them in this suit, they're going to have to pay me up front. Or Karen Reed wants me to represent her. They're going to have to pay me up front. The nice thing about being paid by the hour is it's less than contingency. Contingency costs the client more because of the risk, right? So because you get like a third or 40% of whatever damages. So you can get a lot more than you can hourly. But of course, it's a risk. It's like, yeah, the risk profile is too high for my blood. It's like, you're paying me by the hour and you're paying my fees as we go. If you stop paying me, I stop representing you. That's how that works. You stop paying me, I stop representing you. Good luck. And also, I want $500,000 in the trust account before I move. That solves that problem right up, right? Then I don't have to worry about doing it for the principal of the thing. I'm doing it for the $500,000 sitting in my trust account. Yeah, good times. Can Karen Reed drive again? Yeah, sure she can. I believe so. I don't believe her license is automatically suspended as a result of the DUI. So unless the DUI conviction results in a suspension, which it might under state law, other than that, sure, she could drive if she wanted to. Why would Proctor be held to HIPAA? He's not. Yeah, well, why? Because he's not a covered entity. Yeah, the reason HIPAA doesn't apply to Proctor is that Proctor's not a covered entity. HIPAA only applies to covered entities. Long story short, medical practitioners and insurance companies. That's why he's not a covered entity. So yeah, that's why HIPAA doesn't apply to Proctor. That's easy. What do I think of Proctor appealing his termination? Good fucking luck is what I say to that, man. I look forward to that lawsuit is stupid. It applies to nurses? Yes, because she's a healthcare worker. Right, because she works for the hospital, correct. Yeah, the medical practitioners and the insurance companies. Yeah, that's who HIPAA applies to. Medical practitioners, the hospitals, the hospices, and the insurance companies. That's who it applies to. All right, let's see what we got in terms of interviews from today. I believe we did this interview from NBC 10. Yeah, I think we did this one already, but we'll double check. Is this Today's Show?
Join now.
Yeah, this is Today's Show. So we watched that interview. Okay. Karen Reed, Attorney Jackson blasts the special prosecutor. I bet he did. Unless we can watch that. That'd be fun. We work in a state hospital and we're held to HIPAA? Yes, because you're a medical facility. Right. Yeah. Healthcare workers, hospitals, insurance companies. Yeah, those people. Yeah. All right, let's watch this statement.
Breaking news, attorney Alan Jackson releasing a scorching new statement on behalf of Karen Reed. Investigative reporter Ted Daniel broke this story within the last hour. He joins us live. Ted, this statement, strong words to say the least.
Absolutely. Just when I thought this case might be winding down, nope, it ramps up again. This is a targeted statement, and Alan Jackson takes aim right at Special Prosecutor Hank Brennan and Norfolk County District Attorney Michael Morrissey. Let's get right to it. Jackson says, quote, the jury has spoken, but Special Prosecutor Hank Brennan, in an egregious breach of prosecutorial ethics, has tried to publicly shame and discredit that very jury. For him to attempt to supplant his personal views of the jury is a desperate...
OUI wasn't on the indictment? It was there the entire time. The OUI was there the entire time on the indictment. It was there the entire time, God damn it. $5 from Susan Schaefer. Would Karen Reed be able to use the depositions of civil case towards the 1983? Yes, she can use any of those. She would be able to use any depositions in a civil case. Yes, she can use any of their testimony that was sworn to. I don't know whether or not she can use the grand jury or not. I don't know whether she can use that, but she can use any of their statements from trial. She can use she can use all those things. That's fine. Yeah. Manslaughter while OUI necessarily implies OUI. Thank you, David. Yes, it's not manslaughter. It's manslaughter while OUI. It's a separate charge. They have a separate charge called manslaughter while OUI. So OUI was there the entire time. That's the conceit. Yes, it was. It was there the entire time. That's the conceit of a lesser included. That's how it works. Damn it.
Attempt to save face in the wake of a unanimous rejection of the prosecution's case. Jackson goes on to say, quote, the Commonwealth's defamatory public comments ring hollow to the very constituents they are supposed to serve. It is now crystal clear that disgraced DA Michael Morrissey has no interest in actually seeking justice for John O'Keefe by identifying and prosecuting the real killer or killers. Jackson appears to be responding to the statement Hank Brennan put out yesterday. That's Brennan right there. Brennan described a campaign of, quote, intimidation and abuse by Reed's camp, calling it the antithesis of justice. And Brennan said no one else was responsible for John O'Keefe's death other than Karen Reed. We have reached out to Hank Brennan and DA Morrissey's office this afternoon. Carrie, Jackson's full two-page statement, we have it on our website, boston25news.com.
And Ted, we were talking about this earlier. We really still haven't heard much yet from the DA in this case, from Morrissey.
No, we have not heard a lot from the DA. All he gave was that 4-sentence statement. Let's look at what's happening here. Karen Reed clearly has the momentum. She won in court in a big way, and I could only think that Brennan's statement from yesterday really rubbed Reed's team the wrong way, Carrie, and they didn't want Brennan to have the last word here.
2 pages of not having that last word, Ted. Thank you so much. We know you're going to stay.
All right. Well, that was exciting. All right. Let's see what else we got. All right. So we got another interview with the jury foreperson. All right. Let's see what this one is. This will be interesting.
What raised questions for you about the police investigation?
What raised, first and foremost, the house. I mean, if I was in that house, I know that house would have been stormed, first and foremost.
Probably.
Like, no one went into the house.
Yeah.
Someone's laying on someone's lawn.
Yeah.
But no one goes in the house.
Yeah, that's facts.
It just doesn't make sense.
Yep.
In large part. And that was just one hole amongst many holes that we had to sift.
Sorry, you can't see the video. My fault. My bad. Sorry.
How would you describe the police investigation into John O'Keefe's death?
No justice in a certain aspect. It was really say shot, not even say shoddy, because then I would say lazy police work, because in large part there's certain things that you kind of learn 101 about collecting evidence, making sure no one's near the crime scene, how you do when you talk to witnesses, all those things 101, they was all done lazy. When how do you have interviews with all the people all at once that's supposed to be suspects? No one was separated. It was all done in one group. That alone, it just leaves so many speculations and everything. It was nothing to grasp on.
Do you believe there was any collision?
No, I believe Karen Reed is not guilty.
Did it put extra pressure on you being the foreman?
When I first received the message, at first I was like, okay, let me see. But then when I got in the room and all the evidence there, I was like, whoa, okay, now I got to orchestrate this. But it was truly a group effort, and we all trusted each other. All the jurors trusted each other after having, we could call it a friendship in which we had amongst each other.
Cool.
In which we understood what was going on in the grand scheme of things.
How did you approach this case?
Well, I approached it like how any juror should be approaching it, and walking in there understanding this is supposed to be an innocent person, and now the prosecution has to prove the charges.
Yep, that's it. Yep.
And
yep, that's right.
the prosecution didn't prove the charges.
Wow. I mean, that's it. That's it. Yeah, they're supposed to be innocent. They have to prove it. They didn't. End of analysis. Great. I mean, yeah, that's the right answer. This is fantastic. He's saying, is he secretly a fan of my channel or something? I don't know, man. He's saying all the right answers. This is great.
It was a aha moment, like, wow, they're reaching. And which was when they talked about the holes on the back of the hoodie and everything, and then they had to point back and bring us back in and tell us, no, those was holes that was made by the forensic person. And it was like, oh, so how we...
Defense Stars, I see you lurking in chat. I don't know how long we're going to be here, if we're going to be here for any particular length of time, but do you want to hop on stream and just chat about something, or just chill out or hang or whatever? We could play games. We could play some Jackbox or something. That might be fun. I don't know. You want to chill? What's up with you? What is this? Law, explain, and chill? That's a great pickup line. Hey, Defense Diaries. Hey, Defense Diaries, you wanna law, explain, and chill? Let me know.
Again, more holes that we have to sift through. And
you'll pop on? Okay, hold on. I'll say it's set up. Give me a second.
Being played.
What evidence stood out regarding driving under the influence?
Well, her own testimony. That's what really kind of what solidified it. We looked at 3 different clips, and then we counted all the drinks at the 2 bars and everything. If she sipped, if John sipped, all these different things. Did they share, whatever? Did she actually? And then we tried to look at all that, and we went over. We went over the videos twice, and then we went and counted the drinks, and then we looked back at her videos, and we was like, this is the only thing that's solid. This is the only thing we really have that's solid, that we could feel honestly, truthfully, like we could charge her only with this.
Facts. I mean, that's pretty basic stuff, man. Like we don't have to overcomplicate this. It's like this is great. This is just all the right answers. All right, let me send this link to Defense Diaries real fast so they can pop on for however long we're going to be here. I miss hanging with people. How did this happen? All right. Yeah, all right. Nope, that's the wrong link. Let's try this again. There we go. That's the right one. All right, now that Defense Diaries has the link. Okay, cool. We'll give them a second to pop on, and then we will bring them on stream. So let me get that set up, because I have to do this the jank way, but that's okay. I'm here for jank. We know we can do jank. If you leave me now, take away the very best part of me. Ooh, darling, please don't go. Bum, bum. All right, cool. Now we're all set up for that. So we got that setting up, ready to go. Great. Let's see what there was in terms of a next clip. We could watch Bruce Rivers' thing. He did a little discussion on it. We could watch Bruce Rivers' discussion. I haven't watched it yet. All right, let's watch this thing. Oh, this is the TMZ verdict. Did we watch this already, this TMZ interview? I think we watched the TMZ thing a while back, didn't we? So I think we watched that. And Hank Brennan Breaks the Silence. We watched that, I think. Yeah, because we watched the TMZ thing. But I don't remember him discussing like that they were still doing manslaughter the day of the thing. I don't remember him saying that in the interview with TMZ. So where did a juror say that they were discussing even manslaughter the same day they returned the verdict? Does anyone remember where that happened? Ads are annoying. I'll turn them off. Sorry. I'll turn them down at least. I love if you and Defense Diaries are streaming analyzing the CTV. Very interesting self-defense. And the skip button isn't working. I'm sorry about that. You could always download an ad blocker, just, or YouTube Premium, of course. I pay for YouTube Premium, but I use YouTube more than enough to justify it, but that's me. I don't see ads. Well, either you have a blocker or you have Premium or something. I don't know. Karen Reed, juror, speaks about the verdict. This is this interview at night. I think we watched this one too. This interview at night. I think we watched this one. Well, it's 3 minutes. When does this come out? 6 days ago? I think we watched this, but let's give it a shot.
We couldn't.
Oh, what's going on? Is this not in a Chrome tab?
What raised questions for you about the police investigation?
Now let's do this.
We couldn't.
Okay. Share screen. Okay, yeah. Okay. And do it the jank way.
Prove there was a collision and she was responsible for John's death.
Tonight, a juror tells WBZ she is confident in her decision to free Karen Reed. Good evening and thanks for joining us. I'm David Wade. There was immense pressure on each and every juror to reach a verdict in one of the most closely scrutinized cases in recent memory. And tonight, one of those jurors is revealing how she decided on not guilty. She just spoke to Tammy Mutasa, and Tammy, this juror, says that she changed her mind as the trial went along.
Yeah, David, tonight, Paula Prado says it was a very emotional and intense week. She actually left the courthouse crying yesterday because she said she felt on one hand, she felt like Karen Reed got justice, but on the other hand, she felt horrible for John O'Keefe and his family and wants him to get justice too.
I was happy for Karen Reed and her family. Of course, I think justice was served, but see John O'Keefe's family leaving the courthouse was melt my heart. I'm a mother, and I saw her pain through all those days.
Paula Prado is recounting the gravity and emotions of being one of the 12 jurors in the high-profile Karen Reed retrial. It's one day after the jury acquitted Reed on her most serious charges in the death of John O'Keefe, her Boston police officer boyfriend.
I just want to tell them it's not our fault that Karen Reed is not convicted, even if there's any chance she's guilty of something, of hurt him somehow. The Commonwealth and the investigators didn't do their jobs too.
How you doing?
I'm good. How are you, Kurt?
I'm good. I miss everybody.
Me too. It's lonely. It's lonely out in the streets.
It's like, hey, you got any of that? You got any of that trial? Yeah.
All ashy.
You know I'm good for it, baby.
Just ashy lips, cracked lips. Yeah, it's I mean, I'm not gonna lie, the first couple days was nice to be able to kind of unwind from it because covering it was a lot. And for us, we're Midwest, so we're central. So it was early starts and it was taxing. So I was happy to take a couple of days off from it and just watch it all unfold.
Yeah. Well, it's been interesting, just in the aftermath of the whole thing. And the juror interviews have been informative. Of course, It's nice to get some information. Sounds a lot like a lot of them understood the assignment. It gives me some assurances. I really liked, I think it was Today's show, when they asked the foreperson, what do you think happened, John O'Keefe? He's like, not my job. I'm like, that is the best answer I've ever heard in my life. That is a great answer.
It was so great. That he crushed two answers. And the first one was, I went in there from day one, believing that Karen Reed was innocent, or that Karen Reed was an innocent woman that had to be proven beyond a reasonable doubt that she wasn't. He crushed that. And then, you just said, he was, I was a huge fan of his. I'm like, my God, the jury system still works, or at least it can. It's got the potential to work.
At least some of the people understood. It's like, wait a second, it's supposed to be presumption of innocence, and the state's supposed to prove things. And I don't know, man. I'm having some problems here. Maybe not guilty sounds like the right answer. I'm like, yeah, that sounds pretty good to me.
All day. Yeah, I was so thrilled to say it, because I know you talk about it all the time. We do too. So the presumption of innocence isn't it's not an option. It's like when I get in debates with people on, our channel or what have you, because, we always take positions. Like we had a position in the Allen case, and, and I'm always up for the debate. I enjoy it. I don't shy away from it. If I'm taking a position, I'm taking it for a reason. So I can usually back it up with something factual or at least a decent argument. And, and I always try to get people to understand that the concept of presumption of innocence is exactly that, but it's one that you have to train yourself to understand in a way that is where the defendant starts. They're an innocent person. And, from trying cases, man, and it's always, one of the first things that we asked on voir dire, I'm like, just by operation of this person being arrested, do you think that they may have done something wrong?
Yeah.
And it's one of those things. It was heartening to see that the foreperson got it. And it seems like he was able to express that to the jurors, maybe weren't quite as clear on the concept. So whatever the case may be, and there was all the hubbub with, Canoni, was this the fix was in and she picked this guy, handpicked. I'm like, well, if she did, thank you.
Yeah, I'm not sure what she thought she was doing or whatever, but all the rest of it. So did you see my discussion on the somewhat academic question of does the DUI bar a lawsuit by Karen Reed?
I did.
What'd you think?
I agree completely. I don't think that it does. Aside from everything else that you were saying, which was 100% correct in terms of if you walk into that, a lawyer's office with that case, that lawyer is going to.
That's why I said the somewhat academic questions, because having solved that question, I got 5 other problems behind it. Right.
Yeah, right. So yeah. Can you clear the hurdle? And is there an actual suit there that is going to, survive summary judgment? Yes. then you have all the rest of the hurdles. Can I collect at all? You know, I mean, for like the first day of, you know, Civ Pro, it was, you don't sue somebody that you can't collect any money from because it's just bad business if you're an attorney, you know? I mean, from a civil suit perspective.
That's why I'm doing this retainer, not contingency, baby. Retainer, not contingency. I'm getting paid no matter what happens. I guarantee you that.
It's the only way you could do that case. It's the only way you could do it. You know, from either side, you know, the O'Keefe's, I don't know what kind of money Karen has left, you know, and just the cost of litigation. And the other part of it that I think people kind of tend to forget or may not know is that the discovery process in civil litigation, you don't have the protections of the Constitution to hide behind there in terms of depositions and interrogatories. I mean, you can really, really dig in there. And, you know,
for whatever value it has, particularly for Karen Reed, because she has no Fifth Amendment issue at all anymore. So like that's a non-issue. So
exactly,
you can depose her and she has to answer all the questions you ask her. So
exactly,
for whatever value it has, good luck, I guess.
Right. And if you're of the mindset like, oh, well, you know, somebody should file suit, or the McCabe's or the Albert should file suit, I'm like, well, that's where, if they're getting deposed and they start throwing out, you know, their Fifth Amendment right, and you know that creates a problem for them. It's just, you have to be very careful before you run into a civil lawsuit, because the discovery process is much more wide open than it is in criminal cases. You know, I mean, you can just dig a lot, you know, I mean, and what you're trying to get, if you're getting resistance from the other side, you go and you step in front of the judge and you say, hey, this is why we need it, you know, depending on what kind of suits you're going to file and what they're going to sound in, man. It's like, I don't know, if I were all of them, I'd all just walk away. That's what I do.
Yeah, I don't really think any of these lawsuits really are any good, because it's like, well, we're well aware of all the problems with the wrongful death lawsuit because, well, we already know the problems of the case, right? So any lawyer would have to overcome that. Now, to their credit, they only have to get to 51%, so they got that going for them. But still, I mean, damn. But they still have to find people that's going to be able to make that case and experts, and that's a lot. It's like, so that doesn't really feel like much of a winner. And then like Karen Reed's lawsuits, it's like, well, who am I suing exactly for what, and what are my damages, and then all kinds of problems beyond that. I'm like, that doesn't really work. So maybe everyone should just go home.
That's what I'm saying. Just everybody pick up their balls and go home. Like, it's just, you know, from our perspective, hey, we're all about civil suits. Have at it. We'll cover the hell out of them, you know. But in terms of like,
or if you have a big pile of money, because then, you know, I'm happy to do it no matter. I will tell you, I will give you my honest assessment. I will absolutely tell you about all the problems. But it's like, well, it's not frivolous. It is not frivolous. So I can do this. I'm like, yeah, we're probably going down. But if you want to give me like $500,000 while we're at it, like, I'll give it my best shot.
Let's have at it. Right. Exactly. But yeah, that contingency thing, it's a no-go. It is a no-go. Because it's like, we front the costs. It's like, if people don't know what a contingency case is, and I'm sure you've explained it ad nauseum, but, you know, I mean, that's where the
lawyers pay for everything. They pay for costs, fees, everything. They pay court costs, attorneys' costs, fees, experts. They pay for everything. They fund the entire lawsuit.
Yep.
And so all they do is they get a cut of whatever they get on the back end.
Yeah.
Is what they get.
Your evaluation of the potential of being able to collect on the back end is everything in a case like that. And you know,
we were discussing like how that can be sad for some attorneys, or implicitly. We were discussing a case decided by the Supreme Court last week in this telefax case. And the FCC ruled at some point that virtual fax machines didn't count for the purposes of the like anti-spam law. And so the court basically, they had certified a class with real fax machines and virtual fax machines for lawyers. And then they decertified the class. It's like, all you get is the real fax machines. So that was 12 offenses something, and so your damages are $6,000. Congratulations on your victory. I'm imagining the lawsuit for the lawyers was more than $6,000, but hey, I get 40% of those $6,000, so that's great.
Oh man, and you know the amount of money they must have dumped into that case. Wow, what a bath! It's
for
like,
a class action. It's like, yeah, that's rough.
Man,
not a lot of joy at the end of that rainbow.
Not a lot of joy in that one. That's why.
But the Supreme Court gave them another chance, so they're going back, and they might have a chance to reopen, or maybe they can still keep striking at that rainbow. You'll see what you can do.
Yeah, my father's, he's been practicing a long time, and he always told me, he's like, yeah, with the advent of the fax machine, it completely changed the landscape of practicing law. He's like, anything like due date, it always took a week for shit to get, from one place to the other in the mail, because he had to mail all the documents. He's like, once the fax machine was invented, it sped the practice of law up in such a way that it became increasingly more unpleasant to practice it, just because everything's moving faster. And when I started thinking about it, I'm like, yeah, I mean, that makes a lot of sense in terms of,
and now we have electronic. Yeah. It's great. Like for federal, it's like, well, I can just put things on the docket myself because I'm the attorney. It's like I just push it and it instantly goes on the docket, and then the other side gets an email notice instantly about the thing, and that counts as service. And so, like, well, that's all. It's like it's immediate.
Yeah, it is.
So it's like, yeah.
Yeah, there's benefits and there's detriments. It has sped up the practice in terms of kind of turnaround time, but it also is amazing in terms of how many days I used to have to physically either run down to the Daily Center and file something in person or hire a runner to go do it, which was a giant pain in the ass. So from all those aspects, it was really it's pretty nice, but to kind of sit back and think about the days when, lawyering wasn't.
We'll go way old school when the Supreme Court was still actually riding circuit. And we'll talk about how we're defecting delivery at a time when, where the judge is, it depends on what day of the week it is. It's like, are they in my town or not? Who knows?
Right. Yeah. Yeah. So what have you been up to since the case?
Well, a lot of Supreme Court stuff in particular, because it's that time of the year. Supreme Court runs from the first Monday of October to the last day of June. And for a combination of reasons, a lot of cases and more controversial cases tend to get pushed towards the end of the calendar. So we've had like last Thursday, 6 cases get dumped. Like the Thursday before, 6 cases. That Tuesday, 6 cases. It's like 18 cases come out this month or something ridiculous. And so trying to keep up with that. And maybe you can help explain whether or not I have a disease, or the channel is wrong, the chat is wrong, or what's going on, because I think Supreme Court is the best stuff, but it doesn't get the kind of coverage that like these trials do. Like, Karen Reed, huge coverage. I discuss a Supreme Court case. It's like, oh, I might have 500 people watching. I'm like, dude, man, this is the good stuff. But dude, apparently chat does not agree with me. I don't know, man.
Okay. Well, I'm here to tell chat that you are doing the good work, my friend, because that is the law of the land. There literally is nothing more important happening in the legal landscape than Supreme Court decisions that come down, no matter what it be, whether it is in the civil arena, criminal, those cases become the law of the land. It's right. From a different, so I adore that you do that. It's such important work that you're doing. You're informing people literally on what the current law of the land is, what the state of the law
is. And in some cases, the law is changing right before our eyes.
Your very eyes.
It just changed. Bam. It just
like for everyone, like when the Supreme Court comes down with the case and they rule on a case, that becomes the law of the land. It's like, maybe you have to go all the way back to like civics, brother, and just kind of explain like how laws are made. And, when they write up a House bill and that House bill and it makes it through the House and the Senate, and if it's a state law and the governor signs off, and it's not until that law is put into practice when lawyers, the things that we argue about as attorneys with one another, is that we take positions on it, on how this thing applies in the real world. that's when cases get appealed. That's when you start to find out and these things flesh themselves out, because when lawmakers are writing these things, they haven't been put into practice. So they don't know if they work or if it's bad law. You know, I mean, could you imagine if we lived in a world where all the bad law that's existed in our country's history had no way to get, I mean, could you imagine where we'd, like, it'd be a nightmare. So yeah, no, man, I'm with you 100%. I always tell people, I'm like, look, like the only thing that you really need to worry about in terms of presidential elections is how many potential Supreme Court seats are going to open up
right?
that person's term or terms. And, you know, depending on which way you lay, you know, that's how you vote, because that is frankly the most powerful thing that they can do, aside from, of course, starting wars. But, you know, as far as the Supreme Court goes, man, it's like if people just sleep on it. They don't understand the import of it. So I think you're doing amazing work, and I don't think you should ever stop doing it. As a matter of fact, I think you should put your foot on the gas and up it.
I try to cover every case every term to the best of my ability.
That's amazing.
Because it's like, well, I like law, and that's where the law is. That's the law place. So it's like I'm interested in everything they have to say.
With beautifully written opinions, typically.
Sometimes
whether you agree or disagree, you know.
Sometimes there's some really great stuff. Like the one that I liked most recently was Bostock, the one dealing with gays in the workplace and transgender in the workplace. I love that case so much because, well, not for Lisa reasons, it in large part actually changed the way I think about cases. So it was so well written, it actually like modified my first principles.
Wow.
I'm like, this is like, oh, wait a second. No, I think, because it was great. It was like, basically you had Gorsuch as basically this textualist, and you had like Kavanaugh and Alito as a like originalist. And before I'm like, what's the difference? And they're like, oh, this is the difference. I'm like, oh, it's like, oh, this is the difference. Oh, it's like, oh, and it's like, oh, I think I'm a textualist now, not an originalist. I think I'm a textualist now. Okay.
Yeah, it was like when I was in law school all those years ago, and we would call them strict constructionalists. And they were like, you know, like the concept being that it was the forefathers that wrote it, and the strict constructionalist was from the mindset of the forefathers at the time that they were writing it, which was always a hard argument for me to land on. Cause I'm like, I just have to take into consideration the changes in the world that they couldn't have possibly.
No. I mean, I'm not down. I'm not down for that at all.
Oh man, it's like I can't do it. I can't do it. I'm like, we live in a different world that they couldn't have, even the greatest minds back there. And I always think about, you know, from a law nerd perspective, like when they drafted that thing up, and
they did pretty good though, man.
They did
solid,
damn good. What an amazing document. But you like, so Allie, my wife.
Although I do have a few notes.
Yeah. I mean, thank God for, you know, amendments. So I was like, Allie's a Philly girl, and we practiced when I got out of law school. We hung a shingle out in Philly proper, and I was desperately trying to get. Are
you down in dirty Philly?
Yeah, we were down in dirty Philly, man. It was
right.
We were Center Street. So we were like, like when we were trying to find an office, I desperately wanted a place that overlooked Constitutional Plaza, you know, where they drafted the damn thing. And you when you think about them drafting that in the summer, back when people really smelled bad, like there was no such thing as deodorant, bathing,
and they're young. Some of those guys are in their 20s, man.
Just reeking, and no windows open, no air conditioning, just sitting in that room, pounding that beautiful document out. It always amazes me. It's but you know, so it's. I think you do amazing things over here, man, and don't stop. The chat just needs to catch up with you. That's all.
If what really I like it is just because you divorce yourself from like the facts of the case and facts, and you're just like in this pure platonic ideal, because you're just basically a principle. And the cases I like the most are the ones that make me think, because from time to time there'll be a case where I feel like I have to notch my intelligence up, and sometimes even like I don't know what to do. Like there are competing principles or there are competing ideas, and like I don't know what the answer is. I don't know how to solve this problem. I'm interested in what the U.S. Supreme Court will do in solving this problem.
I mean, it's fascinating. It's like I always talk about, you know, if you get into the minutia of any case, no matter how big or small it is. It's all fascinating. Like the laws, if you allow yourself to get into the minutia of the law, it's incredibly fascinating. It just is. It's like I don't think there's anything more interesting, but we're biased, of course, but it's just in terms of like it's got so many tentacles in terms of the impact on society. I think it's the best.
So I'm not out of touch. It's the children who are wrong.
I would argue that you're the most in touch.
All right. We'll go with that principle.
Yeah, it's
what,
right.
What other stuff you following or covering or looking forward to?
Oh man. I guess I'm going to have to dive into Kohberger.
I'm interested to see how that develops for my own view, because I haven't been paying the utmost attention to it. So my opinion is not as informed as it could be.
Right.
But I feel like the case is, it's pretty circumstantial, and based on what I have seen so far, it's a little circumstantial for my taste, especially for the quadruple murder with the death penalty. It's like, I'd like a little bit more than is currently available, but that in some sense might be unfair to the state. Perhaps they have more, or perhaps when it's presented, it will tell a more compelling picture than I currently understand. So I'm interested in this because I'm going into this skeptical, but very open. I'm very interested to see how it develops and whether or not, at some point I'll be like, oh, okay, never mind. Like maybe that will happen.
Yeah, I'm of the mindset, like I covered the Richard Allen thing pretty heavily, and when that probable cause affidavit dropped and then it was sealed, and that really piqued my interest in that case. I'm like, what the hell is going on here? And then when it finally came out a few months later and they unsealed it and I read it, I'm like, wow, this is literally mere presence. Like they literally, their entire case against this guy appears to be mere presence and absolute junk science, like with this unspent casing and nothing else. There was nothing else. Like they had eyewitnesses, none of them.
They do understand that mere presence isn't illegal, right?
Right. It's like, man,
just because I'm present at the murder doesn't mean I did anything.
We'd all be in a ton of shit if that was the case. Could you imagine?
Right. It's like, there's a murder that's happening. That's a murder that's happening. Oh, well, that's interesting.
Yeah. Batten down the hatches are coming for us. Cause I'm pretty sure we were a block away from there. Yeah. And then when the Kohberger, PCA dropped, I'm like, all right, well, this has more teeth. It's still obviously circumstantial. You have probably, and it's going to be highly litigated, but the sheath is in terms of how it's going to impact a jury is going to be very powerful. Just because jurors find that type of evidence powerful. I think it's going to be a problem for Ann Taylor. And I think Ann Taylor's an amazing attorney who's doing everything that a death penalty certified attorney needs to be doing. She's filing all the right things, she's leaving no stone unturned,
Sure, you have to.
Yeah. And I'm with you. I tend to think, and I never make any kind of, obviously until trial, until the evidence has been vetted, I like what I think of it moving in means nothing, but I'm like, I could see that PCA leaning guilty, but it's all dependent on trial. I have to see it all get vetted out. I have to see what's what. And like you said, we only know of the evidence that has been litigated. We don't, if it hasn't been addressed in pretrial motions, we don't know that it exists or leaks. Like my favorite part of that entire trial has been when it got shifted from the original judge to this Judge Hippler. And Hippler don't play games, man. It's like, he's like, I don't know what this practice of filing everything under seal is, but I'm done with it. He's like,
thank God for that.
Oh my God, man. I gave him a
speaking of which, have you ever heard of sidebars being put under seal after a case is over?
No.
I've never heard of this. What is this? Is this a thing?
I have no idea. I've never heard of it. Never heard of it.
Okay. I just want to make sure I hadn't missed a memo somewhere.
Yeah. I've never heard of that anywhere. And I can't understand the rationale behind it. What is the reasoning behind that? She was acquitted. There's obviously no appellate issues that are going to be moving forward. And why in the world would would they seal those? I can't think of a rational reason why at all. And I've never heard of it happening ever. I mean, typically, like when we order our transcripts in our cases, the sidebars are just included within the transcript as part of the process. Like if we had 4 sidebars in a given day of trial, and when we received the transcripts for that day, the sidebars were included, like when it happened within the contents of the.
There's got to be a third party cause of action for me or anyone else to bring suit to get those unsealed, right? Because yeah, it's like, do you want to sue Judge Bev? Should we file a federal action and sue Judge Bev? That'd be good.
Will you write it?
Sure, why not?
Come on, man. I'm on board. I'll get Allie to help with the research. She loves researching. I think because Andrea, she filed something in Allen because she was trying to get her hands on the evidence, and it was on behalf of all of us because the way in that case Gull was allowing actual media, real media, to go up and view the evidence at the close of each day. And she wasn't letting like Andrea, Lee, and I go up and look and see what was there. And it was outrageous. And Andrea ended up filing it. And, very un-Gull-like, Gull ruled on it in a timely fashion and denied it, of course. But, it was like, I
wonder if I can get Pro Hawk up there. Like maybe I could represent you as a podcast because that'd be good. I'll instead of filing in my own name, I'll file it like in your name.
That'd be awesome.
I'll file as a Pro Hoc Vice, get admitted to the district up there in Massachusetts, file in federal court for, and see what cause of action I can dream up. There's got to be causes of action. Yeah.
There has to be. In terms of, I just can't understand under what law or what premise they're allowed to keep that under seal.
I'm loving this plan more and more.
Yeah, I could see it's percolating. I could see literally see the gears moving in your head right now. If your forehead was like invisible or it was like plexiglass, we'd see the gears literally.
If I can manage to get a win out of this, that would be pretty good for my professional reputation too. So
indeed. Well, I could tell you this, you'd have a lot of people in support of what you were doing. Like lawyers and citizens alike. Like it's got that kind of push to it. You know what I mean? You'd have a lot of momentum with it.
I'll do it. I'll do it for free. I just would ask so that we can crowdfund like whatever costs would be incurred, which should be fairly minimal. I'll need the cost to file the suit, which I think is $450, and service a process, and so I'll need like costs. But yeah, let's see if we can get a couple like podcasting, like true crime podcasting groups. The bigger the better would probably be good together.
100%.
And I'll see if I can file a Pro Hawk, and
I think we could probably arrange that within 15 minutes, like in terms of a group. I tend to think that everybody that we know would be more than happy to be named as a party in that. So that's exciting. That's exciting.
I could also represent my my LLC as a separate entity unto myself. So it's like I can sue in because I can sue in my corporate name.
Right.
So I can represent the corporation that is Sensible LLC.
Exactly.
I love this. I love this plan more and more. Okay, great.
I love that you developed the plan.
I might do this. I might do this just because it's interesting. So I'm gonna have to put together a complaint and I guess mail it to the district court along with a motion for Pro Hawk, and I'll have to look up the Pro Hawk rules and see what they are over there and blah 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 blah.
Well,
and see if they're going to give me a problem.
Yeah, I don't think you should have an issue if it's
federal. There might be some local rule with respect to Pro Hawk in terms of what they're looking for. So I have to look up and see if there's any local rules in terms of, whether or not, for example, I need an attorney up there to vet for me, because sometimes you do and sometimes you don't. Whether or not you need like someone who's licensed to like vet for me. If I need a licensed attorney to vet for me, that's a whole other set of problems.
Yeah,
who's licensed in the jurisdiction? Either that or get admitted to the jurisdiction. I could just get admitted. That'd be good.
Just wave in if they have reciprocity. you know, it was
It's not an issue of waiver. I'm talking about federal court. So it's just it's just getting admitted into the jurisdiction.
I think that's what I think you would do. I mean,
because unfortunately, for reasons that I never quite understood. Well, you see, when I was sworn in as a Virginia lawyer way back when, I was sworn in by the Virginia Supreme Court. They actually came themselves personally. It wasn't at the building. It was in a separate room because there were so many of us. But still, the Supreme Court of Virginia showed up and they raised my right hand and I was sworn in. And like I was instantly admitted to all practice in Virginia. Huzzah. And then when I was sworn in Texas, well, in this case, I just did it with a notary because the rules allowed for it. But still, like, you know, I swore the thing and I admitted me instantly to all courts in Texas. It was like, huzzah. It's like, well, I've been admitted to the U.S. Supreme Court. So you would think logically that like all the federal courts should come along for the ride, but they don't. They're all separate. All of them are separate. So I have to get admitted to each one independently. And it's a total pain in the ass. This is also why, like, if I ever get a huge sum of money, it's like I want to do a collect them all. It's like I think there's 250 of them combined when you add in all the federal courts and all the state courts. Yeah. It's like I want let's Pokemon catch them all. Where are you admitted? Just yes.
Right. Yeah, that's it's kind of like my dream of trying to go to every pro baseball stadium in the country. It's the same thing. Yeah, well, it is I mean, it's ministerial, but it's a pain in the ass. It is like getting in other jurisdictions federally. But I don't think you'd have an issue doing it. And if whatever the local rule is, like
I'm going to look it up.
You think Yannetti would be like? It seems like he'd be a guy that would be like, yeah, I'll sponsor you, right? I mean, why wouldn't he? Why wouldn't he? That would seem to be a good sponsor.
I'm reputable.
Yeah.
Let's look it up. Let's look it up together. This is fun.
See what it is.
All right. So let's see. This is Eastern District of Mass.
Yeah, I would think so. It's got to be, right? It's on the Eastern Seaboard.
District court. Oh, it's just one district court. District court for the District of Mass. Okay, they only have one district. Okay, that makes it easier. District court for the District of Mass. Okay, let's see what they got and sort of. Are
you guys excited? This is exciting. You're
watching. This is exciting legal research.
It is exciting.
They really have practiced by pro se litigants. That is not me. Did they not have special rules on ProHawk? They must have local rules. I don't believe that for a second. ProHawk Vici admission. Great. Attorneys not a member may appear and practice before this court ProHawk. The attorney seeking ProHawk must have local counsel. See, that's right away. So I need someone who's admitted in the jurisdiction. Some federal courts require it and some don't, but this one does. So I need it. In order to be admitted, the motion can be filed by attorney seeking admission, but must be signed by a member of good standing. It's the duty of the moving attorney to verify status and blah, 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 blah. Must be admitted, has a member of good standing in every jurisdiction, which I do. No disciplinary proceedings. Yes. Is familiar with the local rules. Sure. Includes full address, all those things. No problem. Yeah, I need a local attorney. Please someone find me an attorney who's admitted to the Federal District of Massachusetts, and we'll go from there. Either that or I just need to become an attorney. How do I do that? Attorneys applying for admission must be a member of the Massachusetts Supreme Judicial Court. See, again, like, why is this a thing? Why to be admitted to the Federal District of Massachusetts do I need to be admitted to the Massachusetts Supreme Court? Like
that's
this,
weird.
Yeah, and it's not that weird for federal courts. Some federal courts require that kind of thing and some don't. But it's not that weird. But it's like, why? Because they're completely separate concepts. But so I can't become admitted because I'm not admitted to Massachusetts. Can I become admitted to Massachusetts, I guess is the next question. And how long would that take? So hold on. Is Massachusetts part of the UBE?
Yeah, I can tell you, Kurt, Illinois, you do not have to be.
Yeah, see, this is why you have to look these things up, because every state has their own little pain in the ass rules. Is Massachusetts part of the MBE? It is part of the MBE. Great. So how long are my scores transferable over to MBE? 36 months. Okay, so I can do this. But I have to do it the hard way. So I can file for admission in Massachusetts. They will say yes. then I can file for admission, or I could just get pro hoc, which will be a lot faster because my admission to Massachusetts would take however long it takes them to do a background check, which, a couple months. So I need a local lawyer. So please find me a local lawyer who will say yes on civil's great, and I'll do it. Are you admitted to the District of Massachusetts? Would you like to represent on civil or sponsor on civil law? If so, please contact me.
So people threw in chat, what about Victoria George? She was the former juror who came in as a jury consultant. I think she's mass barred. She might be I could.
Yeah. Let's see if we can find someone who's admitted to the Eastern, I keep saying Eastern, sorry, by force of habit. Someone who's admitted to the District of Massachusetts, someone who's admitted who will, sponsor me and, blah, blah, blah.
All right, I'm gonna reach out to Victoria George.
Yeah. Tell them we want to sue to get the records unsealed.
Yeah. I'm on it.
Any other attorneys who are admitted to the district and want to join the signature page are more than welcome to join the signature page as well. As long as I get to be lead. That's my conceit. Gotta get them all. Yeah, this is the problem. Like New York has the same thing with its federal district. Like you got to be admitted to New York to be admitted to the federal court in New York. Why? I don't know why, but because you could just do exclusively federal practice, right? That doesn't touch state law concerns at all, if you wanted to.
Right.
So, like, why do you need to be admitted to the state? I don't know. Right. I'm gonna sue the District of Massachusetts for not allowing me to be admitted unless I'm a lawyer in the state. I'm gonna sue the federal court itself.
Well, you're picking all kinds of fights.
See how well that lawsuit works. Yeah. It's like trying to sue the Supreme Court over its own rules. That's good. Yeah, who's going to decide that case? Lord have mercy.
All right, hold on. I'm penning this. I'm messaging her right now.
Yeah.
I'm putting the wheels in motion, man.
Okay.
Just to show people that we just don't sit around here and talk about shit.
No. I think there's a cause of action to be had here.
I agree.
If all else fails, wave the flag, talk about freedom and democracy and transparency and a government of we the people. If all else fails, in honor of our nation's 250th birthday, this cannot stand. Blah, 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 blah.
Okay.
Insert eagle noises.
All right. I've put it out into the world.
Okay, great.
It's out there. It's out there. It's out there for all the peoples.
Yeah. Then I can file. If I get the admission pro hoc, then I can file the complaint, and $450 later, and we will sue Judge Beverly Canoni and her honorable court.
That would be delicious.
Great. What should we watch or react to? We could watch Ian Runkle's interview with the attorneys from a couple days ago. We could watch Foreman's interview with one of the juries. She spoke to a juror for like an hour. We could watch that for a while.
Oh, with
is there something else you want us to react to?
With Paula Pardo?
Yeah.
She's out in the
something
street.
Else.
She's out there. Like we went through like what was good. What I don't want to watch is Proctor. What I don't want to watch, I haven't watched Proctor, and I don't intend on watching Proctor. I did watch the McCabe's and Albert's little 6-minute thing.
Pam Bondi.
Did you watch the thing on the TikTok with Barros? I haven't watched it. I've seen clips of some of the things that he said. People seem mildly annoyed by the fact that it was on TikTok, and I don't know whoever was hosting the interview, but I mean, from my perspective, it was a good get. I wanted to hear from Barros, so I haven't watched that. Have you?
No,
I don't know what the gal's name is. I'm sure people in chat do.
How would I find that on the YouTubes?
We couldn't.
I'm sure that somebody put, like, just type in Barros interview, maybe. I'm sure somebody converted it from the talk over to the tubes. Let's see. I mean, you know what I'm really, really interested in? I'm definitely.
Oh yeah, sorry. Oh no, that interview. Oh no, I tried watching it. I made 10 minutes and I tapped out.
Couldn't do it. Yeah.
Oh no, I couldn't do it. She was so stupid. She was so whatever. And she called Hank Spanky Hank or something. I noped out 11. I made it 11 minutes and then I noped out. I can't do it, man. I can't do it.
Yeah.
I want to harm myself.
That was the consensus. So, all right. So that answers that one. You know what we should both follow, which I think is going to be fascinating. And I think Bradle's a pretty damn good lawyer. And I like the way that he pounds on the lectern when it comes to constitutionality, is Aiden shit, man. Like Aiden's case, when the main case goes,
yeah,
I think is going to be really, really interesting. And it's a really important case for a lot of different reasons. Like, love or hate Aiden. I happen to love Aiden because, he says shit that I'd like to say, but I would never do it. And he's got balls that are the size of planets, man, because, the shit that he does is takes a lot of balls because, he puts himself in peril kind of knowingly. And when it boils down to it, that's a real First Amendment case, like a genuine First Amendment case that they really did weaponize that statute, especially when you look at what's been going on with the jurors in kind of the social media sphere after the fact. That statute is way more applicable there. And if not, the federal statute's pretty hardy in terms of harassing and intimidating jurors after the fact, after verdict has been rendered. There was some question as to whether or not those statutes apply, and of course they do. They certainly do. And people are like going after. I mean, like Paula is taking it like a champ. I mean, she's leaning into it online in terms of the doxing and like that guy, whatever the towel guy is, he's like doing a deep dive into her father-in-law. It's just like, it's crazy shit, man. So yeah, like Aiden's something that like, I'm going to really encourage you to watch. And I'm going to drag your ass over to my channel if you're not going to cover it to hang.
Oh, I'll be happy to.
Yeah.
You want to watch that?
Yeah. I mean, it's not going yet, but yeah, when that happens,
when's that going to be?
I don't know. I think his next date is like early July.
Oh, okay. I thought maybe it's like now. I was like, oh,
no. It's like, I think it's probably a few dates away from a trial date getting set. So, because they actually won, I think they got about 8 of the counts kicked on a motion to dismiss. So, and Bradle's doing most of the talking. Mark's involved with that case, but like Bradle's definitely lead guy on that. So he's been doing all the arguing. I'm assuming if it gets to trial, Mark's going to get to throw his hat in the ring and be more involved than he has been. But
that's pretty stupid. Have you been watching a lot of the details of the Turtle Boy stuff? Because I haven't been really paying a lot of attention.
Yeah, I think I streamed the last 2 substantive hearings that there were. I definitely streamed the motion to dismiss, which was interesting.
Is there any part of the criminal complaint that passes the left test?
I mean, the problem is I don't know, because I keep asking the question and nobody ever answers it in terms of Massachusetts attorneys. Has anybody ever challenged the constitutionality of that statute in and of itself? Because on its face, it appears to be violative of the Constitution to me. So I don't know if there's been an attack on it, because the way that it reads, it does put reporters on blast if they're going to be able to weaponize it against reporters that are, I mean, like the argument in that case is going to be if some of the techniques that Aiden employed during his investigation in the case would be considered investigative reporting in terms of kind of hard-hitting accusatory questions that are being asked of people, which I consider to be journalism. I mean, that's how it used to be. It's not like that anymore. Every mainstream media company is owned by an individual, and it seems to follow whatever that person's politics are. And so there is very little mainstream actual investigative reporting that takes place anymore. And you really have to rely on independent journalists to do it, So I know it's kind of a long answer to your question. I think if you're looking just at the four corners of the statute, I think that there might be a case. I mean, the judges, there's been two judges on it, and they were pretty clear that it was, it's definitely got it's steeped in First Amendment issues. So they realized that. And the fact that they booted, I think either 6 to 8 of the counts based on the fact. So I think that enough passed the stink test to make it to trial. And if you're kind of just reading the statute and just reading it for, what it's worth in terms of whether or not it's going to apply to Aiden in the way that he handled certain things. I mean, it's going to be an interesting trial because ultimately, I think they're going to have to attack. I'm surprised that Bradel hasn't attacked the constitutionality of that and gotten it up into the Attorney General's hands to litigate whether or not that statute's even viable in the way that they're using it, because they weaponized it to use basically just to shut him down.
Yeah, I mean, in terms of attacking a statute for a facial challenge, you have to prove that the statute basically doesn't have any valid applications. If it has valid applications, you're not going to win on a facial challenge. So attacking the statute facially, probably not. Attacking it as applied, yeah, maybe.
Right.
So whether or not he has that as applied is interesting. Now, my view is that the members of the press, in my view, do not get any special protection from the Constitution in First Amendment analysis, because I don't think that's what freedom of press is talking about. The freedom of press is not talking about the people. It's talking about the technology, literally the printing press, the freedom to literally use the physical device that is the printing press. So that's what I think it means. Or by extension, of course, any other publication technology. So freedom of speech is what you say. Freedom of press is the mechanisms by which you say it. That's my view. Yeah. So I don't think either he nor anyone else gets special protection because they're media certified by anyone else. I don't care if you're NBC or the New York Times or just some guy, because it's a right that belongs to everyone individually. It's a personal individual right. So it protects everyone the same. So whether or not he's an investigative reporter, I think, to my mind, is kind of irrelevant in the end, unless there would be some special protection under Massachusetts state law, but not as a matter of federal law. It doesn't work for me. Whether or not, so my question would be, did he do something that violates the statute would be my question at that point, and what First Amendment principles would extend at that point.
I mean, I think if you were to pull up the statute that they're going under, I think that, and if you kind of look at the things that they're talking about in the indictment or the indictments, it's going to be a hard fought case. I'm not, like, Aiden's pretty confident he's never going to do a day in jail, but it's like, if you kind of think about what's going on, like post verdict, starting with Proctor coming out, and then the night of the verdict, and then I think the next night the Alberts and the that whole crew, the McAlberts, as he likes to call them, they then had their little presser, and then the following day Hank's statement comes out, and he leans heavily into the witness intimidation aspect.
It'd been nice if you mentioned juror intimidation. That would have been nice.
That's what I'm saying, man. Like, when you're like, because like I literally tagged Prado, and I'm like, look, this is the avenue you take. You need to contact the jury commission over out there, and they will absolutely, with a complaint of what's going on online, and pick the fight. I mean, there are ways that you can protect yourself, and they have laws in place to help you with that. And I just tend to think that they're really trying to angle towards pointing all the guns at Aiden now. Like, I think he's going to become the scapegoat in terms of they couldn't get the conviction on Karen, so they're going to do everything in their power to convict him. That's the way this seems to be lining up to me, and it's scary, because bottom line, I mean, when you get to brass tacks, like, none of us are talking about Karen Reed if he hadn't started screaming about it. He screamed so loud and it caught the attention of all of us,
Yeah, for sure. And that's why they're going after him, because he prevented from pinning it on the girl.
That's right.
So someone said I should react to this thing, so perhaps we can react to it together. From Turtle Boy News, Canton cover-up part 519. The fact that there's 519 parts is mildly hilarious. My response to comments I made about post-verdict professional relationship with the Karen Reed defense team. Okay. Let's see if I can make this any bigger so we can read it. Okay. I just want to address comments I made on my show the other night that become fodder for social media. Karen Reed's team is not distancing themselves from me, and I'm sure I'll be able to sit down and have a recorded discussion with them eventually. The only reason I ever brought it up was because people kept asking me if I was going to have them on in light of Alessi and Yannetti's appearances on our channels. Yeah, they do seem to be doing a tour. Incidentally, by the way, why haven't you appeared on my channel? I'm not feeling the love.
Yeah, me either.
I've always been straightforward about what's going on, so I answered the question truthfully. This is perceived as me being bitter, but the truth is I was just answering a question. In fact, let me be clear. Karen Reed and her team don't owe me anything. I didn't do this for accolades, thank you, or money. I did this because I love investigative journalism and been doing this sort of work for 11 years. I love digging into stories and reporting what the rest of the media isn't. I love uncovering corruption, exposing people who behave badly, and helping innocent people. It's a very satisfying line of work. I'm lucky and blessed to be able to do it for a living. Well, it does seem to be working out well for him, but for the most part. So,
Yeah. Good on him.
Yeah. I wrote about the Karen Reed story because it was a story that wasn't getting properly told by the media. I'm still interested a little bit, and I don't know. I asked Turtle Boy this question, like, why do you, because he said, like, well, there had been some news reports about it in the media, to some degree, but, it was a story that fell off the radar.
Yeah.
And so for whatever combination of reasons, he read a filing that was on the public docket, as you can do, and he covered it. So I was interested, like, from his point of view, or why does he think the story gained legs? Like, what? And he gave an answer, but it's like, I don't know if there's a more satisfying answer to be had. It's like, what about it? What about it, for if no other reasons than I want to make my stories go viral, like for selfish reasons too? Like, what about it is made this work?
I thought, and I have a thought on it, and that Richard Allen case that I covered so heavily, there was one thing in common that happened with both those defense teams, which you don't typically see, because the one thing that we don't have to give the government a heads up on is what our theory of the case is. We can hold that all the way up and through trial, up until we need to present it.
Unless it's an alibi witness, you have to tell them that.
Exactly. And if it's anything other than an alibi witness, I mean, we've got to put it out there. But in terms of their theory, it was the motion to dismiss explicitly is what he got his hands on. And I think the way the story goes is one, like, somebody made him aware of it. We're like, hey, you should really read this, because they laid it out. That's where they lay out the whole conspiracy theory right there in that first motion to dismiss that they filed. And it was a really fascinating read. And in the Allen case, it was the Franks memo, where they did the same thing. They essentially, that was the 136 page Franks memo. When that thing dropped and I read it, like, I was like, first of all, I was like, wow, I've never read a legal filing like this in my entire life. When I had Andy Baldwin on, the guy who drafted it, he's like, yeah, I'd never written a Franks memo. So I was just like, I was going at it. But what we had in both those cases, you had both defenses laying their entire theory out of the case out very, very early. And once they started getting picked up and they started getting eyes on it, you had this unusual circumstance wherein people started taking sides, because typically the way it goes is we hear from the government. The government, they throw out their indictment. They'll have their probable cause affidavit. You'll read what their theory of the case is. That's what the media picks up. That's the story that's put out to the public, usually for the entirety of the pretrial process. And in these two cases, you had it where the defense had put their entire theory out, and there were enough people out there that thought that their theories had legs to where it created this huge division in, where people are like, oh, I think she's guilty, or I think she's innocent, or I think he's innocent, and I think he's guilty. So you have this divide there. And I mean, the difference between the two cases is Gull, as you know, would not allow the trial to be streamed. So that it didn't catch fire the way that it had, because the shit that went down in that Allen case is frankly far more disturbing than anything that went on in Reed's case. I mean, she shut them down from bringing forth any kind of third-party culprit defense at all. Like not even through, kind of a Bowden, which is a Massachusetts case, but through an ineffective investigation type vein. They couldn't bring it up at all. She barred them from even mentioning their names at all. And it was like she completely kneecapped the defense in that case from putting forth any other defense of any substance, and they were left just leaning into reasonable doubt, which was insane to me. I mean, in that case, in Allen, you had people that were, that had confessed to doing the crime. I'm like, wait, how is that not a nexus? Wait, you're saying that his confessions made in prison while psychotic are valid, but you're saying that this guy who made a confession to being out in the bridge and spitting on one of the girls and seemed to have some facts that other people that weren't involved with the case wouldn't know, that's somehow not a nexus that the defense should be able to put forth. So it was just so I think that's where it was born out of, man. I think that he was able to, and what he did, that's where I was talking about his huge balls, because he took what the defense's theory was, and then he acted on it. Like he went out and he started grilling. He was trying to question all these people that they were saying were involved potentially in John O'Keefe's death. And that's where it got crazy. It was just, and he was relentless with it. So like, that's kind of my theory on how the whole thing got just to the point where it is now. I mean, and once you got the hung jury with the first trial, the thing just took on a life of its own, because it was really nationally probably still not getting a ton of coverage. I mean, Law & Crime was doing some on it in court TV, but in terms of, turning on the 10 o'clock national news, you weren't seeing anything about it. You know what I mean?
Yeah.
But once the retrial was happening, then everybody's like, yeah, well, maybe we should take a peek at this Karen Reed thing. People seem to be pretty interested in it. So I don't know, man. I don't know. I think it was, but the one thing that they both had in common, the common denominator, was the fact that both defense teams decided we're going to lay out our whole theory, which, there's potential pitfalls of doing that,
Sure.
And you kind of see it. I mean, you're kind of giving them a heads up on where you're going to go in terms of defense beyond just, obviously naming your witnesses. And as you said, if you have alibi, you have to disclose that. But I don't know, man. The thing just like I'm literally trying to get everybody that was behind that Karen Reed movement over to Allen, because he was convicted, and I sat in with Andrea and Lee every day of that trial, man, and it was like they don't have any evidence against that guy. They just don't, and nothing about him to me speaks to him being the guy who would have done this. I mean, he was, 47, 48 years old, no criminal background, no history at all. And, they didn't find anything that you would think would exist on his electronic devices that would kind of be a red flag, like, oh, this guy's building up to something awful. And like, there was nothing like that. It was just a dude like who 2 days after the girls went missing, went and volunteered that he was out at the bridge.
That was a mistake.
That was a mistake. You know.
So what is the continuing lesson here? It's like, you know, when you have things like that, and you also have other situations where the police misbehave, it becomes a lot more understandable why people don't want to cooperate with the police from purely self-interest reasons. Because, like, I'm going to get penalized for cooperating.
Yeah.
It's like, you know, possibly going to jail.
Yeah.
So the police come knock on my door about a murder that happened. My incentives are to, like, not say anything. I'm not home. Talk to somebody else.
Right.
Right?
Yeah. I mean, what do you have to gain from it?
Not much.
You have way more to lose potentially than you have to gain, which is scary, you know, or get a lawyer, you know, have a lawyer. It's a pretty simple rule. I don't care what position you're in, whether you're 100% guilty of doing something, they come knocking, or you're 100% innocent, you should have an attorney with you present without exception.
I'm not sure how much having an attorney would help you, because if I'm your attorney, my advice is shut your face.
There you go. That's enough. At least you can go in and say, yeah, well, you know, I went in with my attorney. He told me to shut my face. So I follow the advice of my attorney, you know, because like otherwise it's, you know, that gets them digging in. It's one of those.
And they're going to be frustrated because, you know, they're going to bring my client in, you know, because let's say he's a witness, they're going to bring him in. My client has decided to hire me as an attorney, as his attorney. I'm like, okay, you don't have to say anything. You're under no obligation here. So shut your face. And so they ask him questions, and it's like, on advice of counsel, I'm not going to answer. It's like, we just think he's a witness.
Yeah.
And I was like, yeah, well, you know, what is the professional version? What's the professional version of, you know, go fuck yourself then? That's not my problem, right? That's basically my answer. It's like my client is under no obligation to help you. It's like, my client can't hinder you. He can't impede you, but he doesn't have to help you. So it's like, you know, you can do your investigation. He's not stopping you, but he doesn't have to answer your questions. That is not impeding. Go to hell.
Right.
You want to bring obstruction charge, shove the obstruction charge up your ass.
Right.
You know? Exactly.
I mean, and it's, look, I mean, you see it time after time. I mean, anybody, and it was so frustrating. Like back when I was really heavily practicing, you know, and I had repeat customers, you know, and I'd be like, man, you know, I told you the last time that you were in talking to me.
And I don't know if I'm on the wrong side of YouTube sometimes or what something, because I sometimes wind up in these rabbit holes where I wind up on police behaving badly videos. And it just like pisses me off. Like because I get outraged. Like I saw a video where the police come into a person's house. They're inside his house. You know, they're not there with a warrant. They're there to do whatever the guy tells them to leave, and they won't leave. I'm like, you're trespassing. He just told you to leave. And they're like, and he actually says, you're trespassing. It's like, well, we're not leaving. It's like, and so I'm like, this pisses me off. Or the old thing where the police like put their foot in the door. It's like to prevent you from closing the door. It's like, you can't do that. And then they get mad, you know, and all the rest of it's like,
they get mad. They get very angry.
They get mad.
Yeah.
Or the, you know, the auditors, it's like, give me your ID. And like, no, I'm not going to, because I don't have to. It's like, yeah, you know, you're right. So it's like, and then they get mad.
All right, I got to dip. I got to go for my wife's got an appointment. I got to go.
Tell your wife about our super secret plan.
I will. Have fun. Thanks for having me.
Thanks for dropping by.
I'll hit you up.
Where can people find? I've never heard of you before. Who the hell are you? And where can we find you?
I'm Bob Mata. You can find us over at Defense Diaries. That's our channel. And
Defense Diaries.
That's the one.
Oh.
That's it.
What kind of things do you discuss on Defense Diaries?
We do all of it, man. We do. We cover trials. We obviously cover. We love pretrial work too. We love the motion work. We handle all the stuff before the stuff that you love to handle. All those Supreme Court decisions you like. So we're down at the trial level. That's where we live.
You know what I'm really looking for in my day is a true crime podcast. You wouldn't know anyone who could serve me up that need, would you?
Yeah, I'm your guy.
Okay, great. All right. Well, thank you for dropping by, and we look forward to talking to you later.
Thanks, Kurt. Thanks for having me, brother.
No problem. Bye-bye.
Bye.
That's how you do it, baby. That's how you do it. Yeah, that's the way to go, baby. I'm looking for a true crime podcast. I don't know where to go. Come on down to Bob's True Crime Podcast. That's fun. I enjoyed that. That was a fun discussion. Lord. All right, finishing up this thing with this story. I wrote about the Karen Reed story because it was a story that was being properly told. I was shocked on April 17th when I read about all the court filings and spent 2 hours doing a deep dive. I feel it. I published part 1 of the Canton cover-up series at 3:30 in the morning on April 18th and never looked back. The story didn't take off because I sensationalized it. Yeah, so this has been going on for 2 years now, man. 2 years. The story took off because of the facts and the evidence were so shocking. Like many of you, I had no idea our institutions could partake something that's so transparently evil, or in the best possible case, just wildly incompetent. My reporting and activism is not the reason Karen Reed was free. Dr. Lapazada, Dr. Russell, Dr. Rentschler, Dr. Wolf, Dr. Scortibello, Lucky Longan, who continues to be the best witness in this case. I will fight you. I will fight you. I'm on Team Lucky 100% of the way. Team Lucky is the best witness in this case. I will fight you. I have to change because, yeah, let's change to a, there we go. That's a little better. Let's change to this layout so it doesn't look so jank. But I will fight you. Lucky is the best witness in this case. Come after me. He's the greatest. ARC is okay and all. I mean, the defense team is okay and all. I mean, they're all right, you know, if that's your kind of thing. But Lucky's the best. All right, great. Yeah, Lucky Longren and Nicholas Barros were the people most responsible for her freedom. It was their truthful testimony caused the jury to reach that John O'Keefe wasn't hit by a car and therefore Karen Reed didn't kill him. You could argue that Hank Brennan, Yuri Buchanan, Judd Welcher, Kerry Robert, Jennifer McCabe, and Kelly Dever, hopefully I got that right, contribute to acquittal more than anyone because the way they behaved in front of the jury proved the Commonwealth wasn't being honest. Not wrong. Karen Reed is free because of her own investigating, the fine work done by her lawyers and private investigators. That's not to say I didn't play a part. I certainly did. My reporting supplemented. I wasn't just annoying Chris Albert out the pizza shop. I was filing public record requests, speaking to other witnesses, passing information on defense was useful. I found things in my own investigation and gave them information to Karen and her team prior to publication. I reported that Jennifer McCabe was parked outside Proctor's house on September 25th, 2023, which proved for the first time there was a personal relationship between the two families. The information was used in court filings and the two families could no longer lie in court about that. More than anything, my journalism and activism raised public awareness, and without that, none of this was possible. Not only did the crowds outside lift Karen Reed's spirits, that got to have helped, but they gave her the financial ability to properly defend herself. Well, at least partially, although I'm sure she ran out of money long ago. Because it's expensive, man. I mean, that team was costing $50,000 a day for Karen Reed's defense. That team was costing $50,000 a day. I mean, just do the math. Just do the math. How much does Alan Jackson get paid? How much does Alessi get paid? How much does Yannetti get paid? Right? How much does Little get paid? How much do they get paid? How much is their collective pay? Yeah, do the math. Yeah, it's like $50,000 a day. Yeah. Alessi was free. Okay, let me rephrase. If they were charging their commensurate rates, how much would it be? Okay. If they were charging the rates that they'd be able to charge, how much would it be? Okay, there you go. The Legal Defense Fund was an idea I suggested for Karen Reed and was one of the first people to fundraise it for my earlier shows. We ended up raising more than $1.1 million, which is paid for defense to fly, feed, and lodge all the experts time and time again for their hearings. Yeah, not to mention, of course, that's just the lawyers' time, not to mention the experts' time, their private investigators' time, the paralegals' time. Yeah. The experts are the reason jury acquitted Karen Reed, and every single person who donated Legal Defense Fund made that possible. There's no denying that story helped me professionally. Although I made a fine living with Turtle Boy before the Karen Reed story, I made a lot more money since writing about it, and my social media reach and online profile has grown exponentially as a result. But I would never have the opportunity to do this if the Commonwealth didn't frame an innocent woman for murder. If they had dropped charges after part 1 of the Canson cover-up series, then the story would have been one and done, and most of you would have never heard about it. Instead, they decided to continue to frame Karen Ruth with newly planted evidence, taillight pieces embedded in clothing. They arrested me for asking questions of people who are quite clearly hiding something, and they dragged her through 2 internationally televised trials. They chose to do that, not me. My newfound fame and any monetary gain I came with it was a side effect of their choices, not mine. I've spoken to Karen many times since she's acquitted, but I don't want to bother her too much because I'm sure she needs space. Yeah, facts. Think about what she went through 3.5 years of being framed and tortured by the most powerful people in the state, being defamed as a murderer, having every single word she's taken out of context, and dealing with the constant anxiety of knowing that at the end there was a chance she could spend the rest of her life in jail, which would be mentally and physically killing of her parents. Probably, yeah. Although you could probably imagine what a horrible feeling this must be, you don't really understand until you've lived it. 4 times that's true. 4 times I've stood in front of judges of the Commonwealth as they sought to revoke my bail and put me in jail for 60 days over completely made up charges. 1 time they succeeded, but all 4 times were anxiety-inducing hell. Being away from my kids for 60 days was the worst punishment I ever could have imagined. Talking to them on the phone from jail, pretending I was away on business, which I guess in some sense might be technically correct, is the best kind of correct. I suppose in some sense you were away on business. So is that a lie? I don't know. I'll let you guys figure that one out. And not being able to truthfully answer their questions about when I was coming home was painful. Reuniting with them on February 23rd, 2024 was the greatest feeling of my life. I couldn't sleep that night as I looked at their pictures on the wall and promised myself I'd never been separated again. But just days after I released, Paul O'Keefe and McAlberts brought a woman who had lied about me and sent me to jail with them to the Karen Reed hearing for the sole purpose of having me charged with violating a restraining order. It worked. I knew that 17 days later I'd be standing in front of a judge who would have the chance to revoke my bail again, this time for 120 days. Imagine feeling the joy of being reunited with your kids after 60 days, only to be immediately faced with the prospect of being away from them another 120. Facts. It was the biggest tease ever. I didn't feel truly free until the bail revocation was denied. After that, they've tried to revoke my bail 2 more times. One over window intimidation, which that was really cute. You know, somehow I was talking to a window and there might have been a video feed and somehow that's witness intimidation. That's cute. And another over comments I made on my show about what I would hope happened to the corrupt cot who knowingly participated in framing me. The feeling of standing in front of a judge knowing he has the ability to cause you the worst pain imaginable by taking you away from your kids is a mental hell. Truth. I can't tell you about the amount of nightmares I've had going back to jail. Very true. By the way, incidentally, if you're enjoying this content and would like to support my channel, super chats are welcome. We also accept donations at coffee.com/uncivil, which does not take as much of a cut. So if you'd like to donate not through YouTube takes 30%. Coffee takes like 5%. So if you'd like to donate the same amount of money, but have it go further, coffee.com/uncivil-law is always appreciated. Plus, you can join for a mere 99 cents. It's literally the cheapest memberships that are available. You get to be a member of the channel and have that sense of being a little bit better than everyone else. Plus, you get some cool emojis. You get some behind the scenes content, such as my Supreme Court streams I did recently are now members only. So you can see that stuff. Please support the channel. It is appreciated. Please help feed me. Your donations are appreciated. All right. I'm not telling you this to feel bad for me. I'm telling you this because I know what Karen Reed is going through, as only someone who can live through it truly knows. We were also considering doing like blush. We were considering doing blush as an award tier. For every like 5 super chats of $5, I'd like put on blush or something. I don't know if that's going to catch on, but it was an idea. Let me know if you feel that. I'm not telling you this to feel bad. I'm telling you this because I know what Karen Reed's going through, as someone who can live it truly know. I see a therapist regularly, good for you, and I highly doubt Karen has had time to. What she's been through is not normal. The smiles you see on TV and the confidence she exudes in public are a way of putting on a strong front. I'm not sure, man. I think some of that's pretty real. But she's human, and she knew at the end of this, if she's convicted, she'd be the only one who has to go through the hellhole known as the state prison. No blush. Okay. Although we're all happy for Karen Reed, keep in mind the emotions she's feeling right now might be even worse than what she was feeling before she's acquitted. What she's lived through the past few years has been news and entertainment for us, but it's been traumatic. I mean, she might not even realize it until now. I don't know if she has nightmares and random feelings of severe depression like I was after getting out of jail, but be normal. Yeah, she might feel a lot of different ways about this. Can I do a goal of putting on my hat for the lowest tier? That's not actually a worst idea I've ever had. Okay. So we can do 5 super chats. I will put on my hat. Smiley face. There you go. All right. We'll start a goal. Let's see if that does anything. Lord. All right. As for interviewing her, I had many conversations with her over the past 2.5 years about being the first to interview her, but she never promised me that. It's always something I hoped for, but wasn't something I thought I was entitled to. The matter of fact is she's lost everything as a result of this, including her job, her car. Well, she gets her car back, perhaps not in the same condition it was, but she can get it back, and her house. She has to rebuild her life again, which means she has to make money. As much as I'd be honored to interview her first, the fact of the matter is there's likely a bidding war going on right now. Fair? I'm just a guy with an online news site, and I can't compete with what others offers. I've discussed this with her and think she should make as much money as she can. She assured me that after the first interview, she'd be happy to sit down with me. I mean, perfectly valid. 100% valid. So no, Karen Reed and her team are not distancing themselves from me because they're worried about new charges. What would those even be? Like even hypothetically. Or because I use foul language they don't want to be associated with. In fact, I was the second person Alan Jackson calls after his wife on the day Karen was acquitted. I was invited out to dinner with all of them that night. This is purely a business decision for them now, which I not only completely respect, but I think they'd be crazy and stupid to blow the kind of financial opportunity just to throw me a bone. Fair enough. Thank you, $4.99 from Lucky Snacks for the hat start. It's appreciated. Everything I did with this story was for justice for John O'Keefe. I might get a little carried away sometimes. Yeah, a little bit, Turtle Boy. You can be a little acerbic. And I definitely use foul language. But the fact of the matter is an innocent man was murdered inside Brian Albert's house. And the people who did not only got away with their crimes, but also framed an innocent woman. If this isn't sufficiently outraged to the point where foul language or wanting to get up in people's faces and ask them legitimate questions about why they murdered someone, then you're not understanding the gravity of what an injustice was. I mean, that's perfectly fair. That's fine. Thank you for the 499 KB. I didn't do this for any sort of professional monetary game. I didn't do this to get an exclusive interview. I did this because I was outraged and couldn't remain silent. I'm fine with whatever happens from this point on. I'll continue to do my show and make public speaking appearances, talking about coverage of the story. If and when Karen Reed is up for it, I'll be happy to sit down. But for now, I hope what she does best for her family as will I. You know, we should have Turtle Boy on again and do an interview with him. That'd be good. We should do an interview with Turtle Boy. Let me send him a message. And not probably now, but, you know, do you want to do a post-verdict interview discussion thing? I'll see what he says if he wants to do that. That'd be cool. I missed a super chat. Okay, let's go back and double check. I think I read them both, but let's see if I missed one. Annie's been a member for 27 months. Oh, KB just came in for the goal. I read that. And Lucky, I read. Amanda Page gave $5 for a sticker. Midjourney gave $9.99 earlier. Aiden just posted an 11-minute video regarding his comments. We'll watch that in just a second. Thank you for the $4.99. Music to My Soul, $4.99. So if you sue for that, you'll make sure the hearing is streamed. I can't. If I sue in federal court, I can't. No cameras. I wish. It's not up to me. But no cameras in federal court. I know it's sad. I wish I could stream it. I can't. It's very, very sad. However, I will do everything in my power to make the transcripts available as soon as practical. That's the best I can do. Liz Toppling for $10 for a filing fund. Shared for $50 for filing fund. Thank you very much. Happy Van Winkle 56. What are your thoughts on having professional jurors? I mean, it's a give and take, right? No one's ever really tried professional juries. I don't think it's ever been tried. But a jury of the people brings with them all their own, well, we're a government of the people. And a professional jury would have people more trained on law, but perhaps not as diverse as the community itself. And so there's a trade-off there. But, you know, all those things. And thank you for the $5 from Annie Elf on Civil Law Rocks. That's appreciated. Thank you very much. All right, so we'll watch this statement he gave. Let's see.
Hello, everyone.
All right, it's Turtle Boy. Let's see what Turtle Boy has to say.
Everyone, I just wanted to address some comments that I made on my show the other night that have become fodder for social media. Karen Reed's team is not distancing themselves from me, and I'm sure I'll be able to sit down with them and have a recorded discussion with them eventually. The only reason I even brought that up on my show was because people kept asking when I was going to have them on in light of Bob Alessi and David Unetti's appearances on other channels. I've always been straightforward about what's going on, so I answered the question truthfully. This has been perceived as me being bitter, but the truth is I was just answering a question that a lot of people were asking. Let me be very clear, though. Karen Reed and her team don't owe me anything. I didn't do this for accolades and thank yous or money. I did this because I love doing investigative journalism, and I've been doing this sort of work for 11 years now. I love digging into stories and reporting what the rest of the media isn't. I love uncovering corruption, exposing people who behave badly, and helping innocent people. It's a very satisfying line of work, and I'm lucky and blessed to be able to do it for a living. I wrote about the Karen Reed story because it was a story that wasn't being properly told by the media. I was shocked on April 17th, 2023, when I read all of the court filings and spent hours doing a deep dive. I published part 1 of the Canton cover-up series at 3:30 a.m. on April 18th, 2023, and I've never looked back. The story didn't take off because I sensationalized it. The story took off because the facts and the evidence were shocking. Like many of you, I have had no idea that our institutions could partake in something so transparently evil. My reporting and activism is not the reason Karen Reed is free. Dr. LaPosada, Dr. Rentschler, Dr. Russell, Dr. Wolf, Dr. Scorti-Bello, Lucky Loughran, and Nicholas Barros are the people most responsible for her freedom. It was their truthful testimony that caused the jury to realize that John O'Keefe wasn't hit by a car, and therefore Karen Reed did not kill him. You could argue that Hank Brennan, Yuri Buchanan, Judd Welcher, Kerry Roberts, Jennifer McCabe, and Kelly Deaver contributed to her acquittal more than anyone because of the way they behaved in front of the jury that proved that the Commonwealth wasn't being honest. Karen Reed is free because of her own investigating and the fine investigative work done by her lawyers and private investigator. That's not to say that I don't think I played a part in it. I certainly did, and my reporting supplemented theirs. I wasn't just annoying Chris Albert outside of his pizza shop. I was filing public records requests, speaking with other witnesses, and passing this information on to the defense when it was useful. I found things in my own investigation and gave that information to Karen and her team prior to publication. I reported that Jennifer McCabe was parked outside the Proctor's house on September 25th, 2023, which proved for the first time that there was a personal relationship between the two families. This information was used in court filings, and the two families could no longer lie in court about that. More than anything, my journalism and activism raised public awareness, and without that, none of this was possible. Not only did the crowds outside the courthouse lift Karen Reed's spirits, they also gave her the financial ability to properly defend herself. The Legal Defense Fund was an idea I suggested for Karen Reed, and I was one of the first people to fundraise for it on one of my earlier shows in May of 2023. We ended up raising over $1.1 million, which paid for the defense to fly, feed, and lodge all of these experts time and time again for pretrial hearings. The experts are the reason the jury acquitted Karen Reed, and every single person who donated to the Legal Defense Fund helped make that possible. There's no denying that the story has helped me professionally. Although I made a fine living with Turtle Boy before the Karen Reed story, I've made a lot more money since writing about it, and my social media reach and online profile have grown exponentially as a result. But I never would have had the opportunity to do this if the Commonwealth didn't frame an innocent woman for murder. If they had dropped the charges after part 1 of the Canton cover-up series, then this story would have been a one and done, and most of you never would have heard about it. Instead, they decided to continue to frame Karen Reed with new planted evidence. They arrested me for asking questions of the people who were quite clearly hiding something, and they dragged Karen through 2 internationally televised trials. They chose to do that, not me. My newfound fame and monetary gain that came out with it was simply a side effect of their choices, not mine. I've spoken to Karen many times since she was acquitted, but I don't want to bother her too much because I'm sure she needs space. Think of what she just went through. 3.5 years of being framed and tortured by the most powerful people in the state, being defamed as a murderer, having every word she said taken out of context, and dealing with the constant anxiety of knowing that at the end of this, there was a chance that she could spend the rest of her life in jail, which would mentally and physically kill her parents. Although you can probably imagine what a horrible feeling that must be, you don't really understand it until you've lived it. 4 times I've stood in front of judges at the Commonwealth as they have sought to revoke my bail and put me in jail for 60 days over completely made up charges. 1 time they succeeded, but all 4 times were anxiety-inducing hell. Being away from my kids for 60 days was the worst punishment I ever could have imagined. Talking to them on the phone from jail, pretending I was away on business, and not being able to truthfully answer their question about when I was coming home was painful.
Oh, thank you for the $30.
Reuniting with them on February 23rd, 2024
Gayleen,
was one of
thank
the
you very much.
greatest
It's very kind of
feelings
you.
in my life. I couldn't sleep that night as I looked at their pictures on the wall and promised myself I'd never be separated from them again. I thought I would never be happier when I got out of jail, but the truth is, I was never more scared. Just days after I was released, Paul O'Keefe and the McAlberts brought the woman who had lied about me and sent me to jail with them to a Karen Reed hearing for the sole purpose of having me charged with violating a restraining order. It worked. I knew that 17 days later, I would be standing in front of a judge who would have the chance to revoke my bail again, this time for 120 days. Imagine feeling the joy of being reunited with your kids after 60 days away from them, only to immediately be faced with the process of being away from them for another 120 days. It was the biggest tease ever, and I didn't truly feel free until the bail revocation was denied on March 14th, 2024. After that, they tried to have my bail revoked 2 more times, once over window intimidation and another over comments I made on my show about what I hoped would happen to the corrupt cop who knowingly participated in framing me. The feeling of standing in front of a judge, knowing that he has the ability to cause you the worst pain imaginable by taking you away from your kids again, is mental hell. I can't tell you the amount of nightmares I've had about going back to jail. It's on my mind constantly and will be as long as I'm out on bail. And these bad faith, corrupt law enforcement officials have the ability to lie and file motions that would take away my freedom. Too many times to count, I've woken up in the middle of the night kicking and screaming as I was in the middle of a horrible dream about being forced back to jail. It's traumatic, and I deeply underestimated what it would be like when I got out of jail last February. I'm not telling you this to feel bad for me. I'm telling you this because I know what Karen Reed is going through, as only someone who has lived it can truly know. I see a therapist regularly, and I highly doubt Karen has time to. What she's been through isn't normal. The smiles you see on TV and the confidence she exudes in public are her way of putting on a strong front. But she is human, and she knew that at the end of this, if she was convicted, that she would be the only one who has to go to the hellhole known as state prison. Although we're all happy for Karen Reed, keep in mind that the emotion she's feeling right now might be even worse than what she was feeling before she was acquitted. What she has lived through the past few years has been news and entertainment for us, but for her, it's been traumatic, and she may not even realize it until now. I don't know if she's having nightmares and random feelings of severe depression like I was after getting out of jail, but it would be very normal if she was. Life will never be the same for her after this. As for interviewing her, I've had many discussions with her over the last 2.5 years about being the first to interview her, but she never promised me that. It was always something I hoped for, but it wasn't something I thought I was entitled to. The fact of the matter is that she has lost everything as a result of this, including her job, her car, and her house. She has to rebuild her life again, which means she has to make money. As much as I would be honored to interview her first, the fact of the matter is that there is likely a bidding war going on right now for that honor. I'm just a guy with an online news website, and I can't compete with what others would offer her. I don't have hundreds of thousands or even millions of dollars. I've discussed this with her, and I think she should make as much money as she can off of this. She assured me that after the first interview, she'd be happy to sit down with me. So no, Karen Reed and her team are not distancing themselves from me because they're worried about new charges or because I use foul language that they don't want to be associated with. In fact, I was the second person Alan Jackson called after his wife on the day that Karen Reed was acquitted. I was invited out to dinner with all of them that night. It is purely a business decision for them now, which I not only completely respect, but I think they would be crazy and stupid to blow that type of financial opportunity just to throw me a bone. Everything I did with this story was for justice for John O'Keefe. I might get a little carried away sometimes, and I definitely use foul language that my mother wouldn't like. But the fact of the matter is that an innocent man was murdered inside Brian Albert's house, and the people who did it not only got away with their crimes, but framed an innocent woman for it. If this doesn't sufficiently outrage you to the point where you use foul language or want to get up in people's faces and ask them legitimate questions about why they murdered someone, then you're not understanding the gravity of what an injustice this was. I didn't do this for any sort of professional or monetary gain. I didn't do this to get an exclusive interview with Karen Reed. I did this because I was outraged and couldn't remain silent. I am fine with whatever happens from this point on. I will continue to do my show and make public speaking appearances, talking about my coverage of the story. If and when Karen Reed is up for it, I'd be happy to sit down with her for an interview. But for now, I just hope that she does what is best for her and her family, as will I. Thanks, guys.
Okay, that's pretty basic. Nothing. Yeah, it's fine. All right, cool. So I have two videos from Turtle Boy. Turtle Boy does a journalism investigating why Michael Proctor never spoke with Lucky. He's interviewing somebody. And then where he does this discussion on that. I assume this is from a while ago, though. When is this done? This is from 3 weeks ago. He goes down to the police station, tries to get answers to why they didn't interview Lucky. And then there's a thing where he reacts, I think, to the Today Show. See if this is any.
Now let's be clear.
Yeah, we watched this interview already, so we don't need to watch that again. What else can we react to, Rose? That looks good. Thank you. That's very nice. It pays to be polarizing. That's kind of you. Let's see. What else? Lucky one will be good. It's just a short video where he tries to interview the police, but I guess we can watch it. All right. Am I well hydrated? Not really. I could use some water, to be honest. Bruce Rivers? We could respond to Bruce Rivers' reaction, I guess.
All right, we're at the Keaton DPW. We're here to talk to Michael Trotta. Looking for Michael Trotta. Asking some questions here about some testimony he allegedly gave to Michael Proctor. I want to find out if that's bogus or true, because he said a lot of interesting things in there, and we need to get to the bottom of it. Somebody has to. Somebody's got to get to the bottom of this. So here we go.
Oh, Lord have mercy. I'm not even sure I want to watch this, to be honest. It just feels too janky for my taste. I don't know, man. I don't even know if I want to watch this. I guess I'm committed now. God damn, he's storming in there. Like, I can't be bothered. I'm out. I'm not going to do that. I can't be bothered. That's just, yeah. That's the Department of Public Works, apparently. Let's see what Bruce Rivers had to say.
How many weeks was this, guys? Yeah, it's like, justice prevails. The government didn't prove their case. And the fact that,
Bruce Rivers is looking good.
Karen Reed was not convicted is not a failure of the prosecution. Well, it's kind of, they shouldn't have brought a case like this. They should have done something different, honestly.
Bruce Rivers, he's the criminal lawyer. But who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
All right, Bruce, what's up, man?
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts.
I'm here for fun.
Back in the saddle here with Robert and Nick. And the other Nick, who's not such a dick. But anyway, we are here reacting to Karen Reed and the verdict. I know this is a little bit late, but I was out of town. So, but I think it's interesting to kind of dissect this so you can kind of get a criminal lawyer's perspective on what it means. But before we get to that, this is brought to you by AskALawyer.com. AskALawyer.com is a very effective way to get legal advice for cheap. $45, and they have actual lawyers on standby. And I've actually had people email me say that they've used it, that they've gotten good advice. You can either, if you got a claim, you find out if you have an actual claim. What's the next step? Or they can tell you, hey, look, don't bother. Don't waste your time. That's valuable too. Or if you're doing your own research, they have an AI component. So it's trained in all the 50 states. I know my grandma thinks she's a lawyer in my...
Now we got to skip. Okay.
It's about the initial verdict slip, arguing that it was confusing due to...
What is this? This is Bruce Rivers, the criminal lawyer. Who is it? It's Bruce Rivers, the criminal lawyer. What should do? React to all the self-snitching.
The way it was presented to the jury as guilty and not guilty options for lesser included offenses. Let's just stop right there for a second. What's a lesser included offense?
It's both lesser and included. It's both lesser and included. It tells you right on the tin exactly what it is. What's a lesser included? Well, it's less and it's also included. It's lesser included.
So if you have, like, say, criminal vehicular manslaughter or homicide that's caused, where alcohol is involved, well, the DWI, driving while intoxicated, would be a lesser included. Or let's say you have murder and assault, it would be a lesser included in that. So that's what a lesser included offense is. And the judge, here's the thing. I wasn't really impressed with this judge. I think the judge kind of had it out for the defense, honestly.
Yep, I agree. There's a lot of that problem.
They were from out of town. And so sometimes...
I don't know if that was the problem.
I, on the other hand, feel like when you're an out-of-town lawyer and you go into town, I always get treated better, it seems like. But she initially denied the motion to amend the slips, but later provided an amended version.
Yeah, problems with the jury verdicts, right? And jury slips, man. We had amended slips in the first trial, amended slips in the second trial, man. We just have problems getting it right the first time. And then, of course, perhaps most tellingly, the clerk, when announcing the verdict, had trouble announcing the verdict because of the forms and the way they were designed.
After the jurors raise questions. So one of the things that can happen while the jurors are waiting or deliberating, and they can ask questions of the court. And usually the court will then send a copy of the question to the parties, and then they all meet or they confer and decide what we're going to tell the jury. The defense argued the original slips and structure should lead to errors and bias, particularly because it only had one not guilty box for the entire second charge, while multiple guilty options existed for the. In other words, it's showing a preference for guilty.
I don't know about that, but
no, that's not good. Here's kind of a little clip of the defense, and the verdict forms. Sometimes in verdict forms they have special interrogatories. In other words,
you'd rather watch Bruce Rivers than what? Me? Aww. If this isn't doing it for you guys, I'm happy to not watch this. I just thought, maybe it's something you guys would enjoy, but if this is not enjoyable, we could try something else.
Questions. A case can be won or lost based on the instructions and based upon the verdict forms. So these things are argued in court outside the presence of the jury.
Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, that you not suffer any person to speak to them yourselves, nor ask them if they agreed, nor suffer them to disperse them, to charge their verdict, except by further order of the court, so help you God? Simply because
I'm really hungry.
What they're doing there is they are swearing in the deputy, and the deputy has to swear that he'll protect the jury, and because they can't.
All right, guys, I need 5 because I'm hungry as shit. I need to make my protein oatmeal shake and get some water because I'm dehydrated as shit. I need to take a break so I can do those things. So I need 3 to 5 minutes so I can do all those things. So we will resume. And we will come back. I apologize, but I've been holding as long as I can, and I'm dry, and I need water, and I need food. So I'll be right back. I'll talk amongst yourselves for a second. feel a little better. I got my protein shake. For those of you curious, it's unsweetened vanilla flavor almond milk with 1 scoop of protein powder, casein protein powder, to be specific. 1 cup of oatmeal, and 1 of the small, kind of tubs of Greek yogurt. So you blend that all together. It's very delicious, nutritious, tasty. Incidentally, I forgot to take my multivitamins, so let me do that right now as well. Hold on. Excellent. Very good. All right. All right. So someone tagged me with an interview Laura did with a former Massachusetts judge, which sounds pretty interesting, relating to whether or not Karen Reed got a fair trial. So I think I'm going to skip the react to Bruce Rivers for now, at least. And I think I'm going to watch this interview with also, apparently Turtle Boy was in the chat earlier and I missed him. How you doing, Turtle Boy? He DM'd me and said maybe we can get together next week for a post-trial reaction stream thing, response stream, and so that might be fun. So perhaps next week we'll do something and that could be fun with a post-trial thoughts, commentary, whatever. It could be a fun discussion. But I think for now, what I want to do is I want to skip to this interview that Laura did with apparently a former Massachusetts judge on whether or not Karen Reed got a fair trial. So this could be potentially interesting. This could go in a lot of different directions. So let's see where this goes.
What's up, everybody? Welcome back to another episode of The Lawyer You Know, and I'm incredibly excited to have Judge Carol Erskine come on and talk about what it's like to be a judge in Massachusetts. She was a judge there for a long time. She has a lot of thoughts on Karen Reed's case and just generally what it's like to sit on the bench, weigh the decisions, and make the decisions. Sometimes that can be very tough, and some decisions that can end up in some very high-profile cases. She's told me to call her Carol. I'm going to do my best. It's probably going to still come out as Judge, or maybe Judge Carol. We'll get there. But just so everybody knows in the chat, if we get that comfortable and informal, that's why. I'm really excited. I hope you guys are too. We're going to learn a lot today. Let's get to it. Carol, thank you so much for joining us today.
Well, thank you for having me. I'm really excited about this. I don't know that I could actually count the number of people on X that told me this is the place you have to speak out. And I'm happy to do that because, obviously,
Peter's a good guy, man.
Time educating people about the law and the courts. And hopefully I can get a little bit of that done, just sort of educating people about how it works, how judges view cases, and how things happen or don't happen in Massachusetts.
Yeah, and I want to start there just so everybody knows who we're talking to. Can you give us a little bit about your background and experience, how you became a judge, how long you've been a judge, where you're a judge, before we get into kind of the specifics of what happened in Karen Reed's case?
Oh, sure. Well, I practiced law, I think, for about 12 years. I got into law late, actually. I was actually teaching in a health division in a community college and then went to law school. And practiced in different areas, but doing a lot of child advocacy, a lot of mental health law. I represented hospitals in mental health cases, and did some criminal. And then I was appointed to the bench by the governor. And when I met with the governor said, we need people in the juvenile court, to be to be helpful to families and kids and to address some of the issues that come up regarding children. So, that was quite an honor for me. And I had done a lot of child welfare work in the juvenile court.
Oof.
So I was
Rough
appointed
go.
to the bench.
That is a rough field, man. That is a rough field. Yeah, that's challenging. I wouldn't want to do it. I wouldn't want to do it. Give me the murderers. They're better people. Holy shit, you know what I mean? Christ.
I retired in 2023, so that means I was on the bench for 22 years. And in the juvenile court, I just heard cases every single day. So, the focus in my life has been child welfare and the child welfare system. I've been somewhat critical of the judiciary, the legal system, and the child welfare system in Massachusetts. That hasn't exactly inured to my benefit when it comes to people in the system. I think I'm viewed as somewhat of a rogue judge, and I'm okay with that if I can make changes in the child welfare system. But in my court, it was an inner city court. For 15 of those years, I was the first justice, which is, if you look at Judge Canoni, they call her a RAJ, a regional administrative justice. You hear cases, but you're responsible for case assignments, for the administration of the court, budget-related issues, personnel. So in my court and in the other courts, they call that first justice, and I was the first justice, I think, for 16 years until I retired. But it's an inner city court that had 5 satellite courts around the county, but mostly I sat in the inner city court of Worcester, which is the second largest city in New England. So it was a very, very busy court. It's a very urban court. And in that court, I heard criminal cases, which are divided into 2 types: delinquency cases, where the maximum penalty is detention, putting someone in a detention unit or a commitment to the Department of Youth Services to get services. And then and other dispositions like probation, if you're not going to commit someone.
My first job in law was juvenile law, deep lore. My first job in law was juvenile law. I did an internship for a juvenile prosecutor's office when I was still, was I a 1L at the time? Or was I a 2L? I forget. Yeah, it was an interesting job. I was sort of a research assistant, basically, as well. I always like this story because it's just a funny story to me. My first day on the job as an intern in the juvenile prosecutor's office in Ohio. First day on the job is that my one of the attorneys comes to me and says, "Okay, we're prosecuting a kid for running a meth lab." Now, this would be 2005 or 2006, something like that. So this is well before Breaking Bad. So this kid is just precocious, I guess. So we're prosecuting a kid for running a meth lab. And what we want you to do is we want you to figure out how he figured out how to make meth. We want you to figure out how he figured out to make meth, because we want to try to figure out, like, I don't know, for whatever reason they wanted me to figure that out. I don't know. And I was like, okay. So I got on the government computer. I got on the government computer in the government building in the prosecutor's office, and I started doing searches how to make meth. I started searching like Usenet groups and started searching like other sources, trying to find like how to make meth, and tried to find various sources how to make meth. And that was my first day on the job, essentially Googling how to make meth. What you gonna do, man? What you gonna do? Oh, yeah, that's a fun story.
To the Department of Youth Services. But the other type of juvenile cases are youthful offender cases, and those are teens who have been indicted by a grand jury. And so in those cases, the rules, like you saw in the Reed case, the same rules apply. It's generally the rules apply in all cases, but there are special rules when people are indicted. And in my case, youthful offenders are kids who were indicted for serious felonies like, you know, firearms cases, shootings where there wasn't a death because murder cases are heard in the Superior Court unless the alleged murderer is under the age of 14, which doesn't happen very often. But those cases are usually firearms cases, shootings, sometimes rapes, robberies, can be home invasions, where there's a decision by the district attorney to indict those kids. And what that means in the juvenile court is that I would still hear those cases. It would be a 12-person jury. All the same kind of instructions apply. But I had the option to sentence the defendant to a juvenile facility until age 21 or directly to prison or jail. And so there's a lot at stake in those cases. And every day in the juvenile court, in my world, it's a busy place of arraignments and pretrial detention hearings, dangerousness hearings. So that's the criminal side. The other side of the court are civil cases, kids who are runaways, sexually exploited kids, kids who are in need of mental health services. But the majority of cases in my court were parental termination and child abuse cases.
Tough cases.
When I left in 2023, there were over 1,000 open child abuse cases under my
rough cases
with the other 4 judges in my court. And in those cases, basically what...
Yeah, that's rough, ma'am. That's rough, ma'am. I don't know if I could do that. I don't know if I could do that. I don't know if she's a better woman than I'm a man or something, but it's like it's definitely not my temperament, man. It's too painful. Maybe someone else can tolerate it. I don't know, man. It's rough. Oof.
We're hearing every single day, and there are many trials related to these cases, long evidentiary related trials, involve serious sexual abuse, physical abuse, fractured skulls, broken bones.
Yep, that's great.
Kids who have been starved. And
yep.
In my years on the bench, I think I heard 4 or 5 murder-suicides, which left children behind that
sure.
I had to put those kids
great.
in state custody.
Fantastic.
Abuse, domestic violence. It's very, very serious stuff and requires a lot of judicial attention. Listening, like people probably saw in the Reed trial, but just listening intently to what's going on, handling objections, making sure you're hearing everything you need to hear, deciding motions in limine. So that's pretty much the general day, and that's pretty much what I heard for over 20 years.
Yeah, and I appreciate that, and that's kind of the background that's necessary to understand how different a lawyer's job is versus a judge's job, and what you do day to day, and the decisions you have to make, the research you do, and what you have to all have in your head before making very important, big decisions that affect people's lives very considerably. And sometimes lawyers can be critical of judges. Usually we try to do it in a very respectful way to still respect the position and the court and the bench and the person as much as we can, even if we disagree with them or don't like them personally. But you're sitting there, you've made these decisions, you've weighed, Sixth Amendment rights to a fair trial, witness rights, victims' rights.
A lot more flexibility in juvenile court too, for better or worse. Yeah, a lot more flexibility for the judges and a lot more flexibility in juvenile court. Very different procedures. Very different kinds of courts, very different process. It's kind of informal by comparison in some ways. It's a very different it's a weird place, man.
All come into play when you're making these decisions. And
$9.99 from Larissa Harris. Hi. I had a thought come to light. The state was hiding exculpatory evidence that came to light after the trial. I believe there's something there with Barros. Lawsuit? I don't know what the cause of action would be at this point for withheld material. Well, I guess hypothetically, if the material were if the material were exculpatory enough, if the material was exculpatory enough, you might be able to make some sort of argument that had it been known to the defense, then portions of the trial wouldn't have happened, and maybe there's something in there somewhere. Otherwise, I don't know what your cause of action would be at this point. Yeah.
You ended up commenting on some of Judge Cannoni's decisions and some of the Sixth Amendment rights for Karen Read. What grasped your attention about this Karen Read case?
Well, aside from the evidence which people debated, thousands and thousands of people debated, that really wasn't what I was watching it primarily for. I mean, I was just looking at the process. And so, you know, the issue of fairness, which has, which you hope that all judges have as a priority, because in cases that are criminal cases, there's only one person in the room. And just like in this case, there was one person in that courtroom who had a Sixth Amendment right to confront witnesses and who had a right to what the Sixth Amendment says of compulsory process, meaning that every defendant under the Sixth Amendment has a right to call witnesses and confront witnesses and elicit favorable testimony. And, you know, I think as many people know, the Sixth Amendment is actually a prohibition on the government. It just tells the government, you cannot stop someone from calling witnesses. You cannot stop someone from eliciting positive testimony. You cannot stop someone from confronting witnesses. That's what the framers intended.
Negative rights.
Ago, and it rose out of the fact
that's what that is.
When those in America were still under British rule, they were absolutely not allowed to call witnesses. They weren't allowed to put on a defense. And so that's the historical perspective of it. But it's ever present every single day in a courtroom. Every single day you're thinking about this. Am I being fair? As you said, you have lawyers, you know, just presenting evidence on both sides and you're listening to it. And ultimately, someone's not going to be happy with your decision. You know, if I was hearing a motion to suppress on a criminal case over Miranda issues and I decided to suppress it, well, you know, the prosecutor wasn't going to be happy. If I decided I wasn't going to suppress it, then the defense attorney. So, you know, you go into it understanding very clearly that there are always going to be people, lawyers or other people, that aren't going to be happy with what you decide, but you make the decision based on how you're viewing the evidence, and always with this underlying view, especially in criminal cases, that there's only one person, as there was in the Read case. That one person is Karen Read. It's not the judge, it's not the prosecutor, it's not the defense attorneys, it's not the journalists or anybody watching. There's only one person that had that Sixth Amendment right. And so when there were times that it seemed to people that there was an uneven playing field, you know, what plays into that is the fact that she's the person whose rights supersede everyone else's rights. And so, as you heard at times, Hank Brennan would say, you know, we want a fair trial too, and the Commonwealth's entitled to a fair trial. That may be so, but what they don't have the same entitlement that Karen Read had, you know, related to her Sixth Amendment rights.
True.
So those were the things I was concentrating on.
Yeah, and it's funny, just so everybody in the chat knows, we've never spoken before outside of scheduling this and, you know, 5 minutes before, just pleasantries. And it's amazing to hear you say that. I love to hear you say that, because that's something I talk about all the time. And people sometimes get frustrated when you talk about how the most important person and right in every criminal courtroom is the Sixth Amendment right of the criminal defendant, not the prosecutors, not the witnesses, not the judge, not the public. All of those things are important and can come into play. And when judges make analysis or do their analysis, but especially when we've seen some high profile cases, like, I don't know if you know about the Koberger case in Idaho, there were a lot of motions filed by, you know, all of the media companies, and we want cameras in the courtroom and the judges balancing things. And all of that is really important, but all of it is second to making sure the defendant gets a fair trial, that Sixth Amendment right being so important. So with that in mind, and that's what kind of got you interested in this case, where did you see problems arise for Karen Read throughout her process of these criminal? I don't know if you watched the first trial as well. Whenever you picked it up, what problems did you see coming up?
Well, I think I identified, at least for me, problems that I saw and things that I might do differently. And maybe, a lot of, as you know, a lot of decisions judges make, especially on motions, is discretionary, but it's based in the law. And basically you have someone file a motion and then you listen to both sides, you read the law, you meet with, and I'm sure Judge Cannoni did with the law clerks, or in Massachusetts, they now call them research attorneys. So you just have these people standing by to sort of research it and then put it right in front of you. It's not like, I don't think she went back into, they don't call them chambers, they call them judges' lobbies in Massachusetts. I don't think she went back to the lobby and had to write every single thing. I mean, that's what research attorneys are for. But when I looked at it, I think one of the things I really focused in had to be related to decisions regarding experts. And so
yeah, that caught my attention. The decisions relating to experts definitely caught my attention with the disparate treatment between the two sides' experts. Yeah, that was pretty jarring. Yeah, I agree completely. If the judge just picked a lane, that would be fine. The disparate treatment, though, is the problem. So, yeah.
People listening and watching this, what I'd ask people to do is sort of look at things side by side rather than how we looked at them during the trial. So during the trial, so one of the main examples, and I think things that I posted about, was related to Jessica Hyde. So take a look at Jessica Hyde and then line it up or juxtapose it with Dr. LaPosada. And so you look at the decisions that were made in those cases, and having to do with impeaching those witnesses. In other words, calling attention to the credentials of that person. So Jessica Hyde's going to testify. She's going to testify about phone data, and the person with the Sixth Amendment rights is, through her lawyers, is wanting to cross-examine her about the fact that she was declared to be unreliable related to testimony around the phone. And so I don't think there could be anything more relevant. So just to step back in terms of how you hear witnesses, and I've heard hundreds of expert witnesses, especially in child abuse cases. Was there sexual abuse? What's on the x-ray? Are these fractures? Are they not fractures? It all starts with the basics. What's your name? Where did you go to school? Do you have a bachelor's degree? Do you have a medical degree? Do you have certifications? They turn their CV into the court. And have you ever testified in another court before? Which wasn't really highly relevant to me because there's always a first time that someone's going to testify. Right. But in the case of Jessica Hyde, they wanted to impeach her credentials and her reliability based on the fact that she had been determined just months earlier in Maryland regarding a phone case, determined by a judge that that her testimony was unreliable based on a Daubert analysis, which underlies all these expert witnesses, unreliable. And then the judge makes and then Hank Brennan then says, this isn't right. It's too late in the process. And this is only to malign the witness. It has nothing to do with maligning anybody. You could
say that about any attack on credibility, right?
Absolutely. And you certainly could say it about the way the dog expert witness was treated, and at times Dr. LaPosada. So the judge makes a decision in favor of the Commonwealth and says, you can't bring that in, it's too recent. Well, I have two things to say about that. First of all, you want something to be recent. You don't want something to be 20 years ago. Like in my view, this whole issue of Dr. LaPosada and this 20-year-old nightclub fire, first of all, was it relevant? And secondly, the time factor was there. So Jessica Hyde, for some reason that I couldn't understand, Because if it were in my court and I had someone that another judge had said was unreliable, boy, I'd want to know about that. And I'd want the jury to know about that.
Yep.
But
these are all good points.
The decision is against the defense. And then Dr. Laposado comes in and what do? The defense objects. Why are you bringing in this Rhode Island station fire? It's not relevant. It was 20 years ago, which is the more important aspect. You want something to be recent.
Sort of, yeah.
And it was
that's
totally
fair point.
irrelevant. I mean, completely irrelevant.
Yeah, these are not invalid.
But they allowed it anyway.
Well, I mean, if we're gonna start getting into what is relevant and what's not relevant, man, we're gonna have to have a whole host of discussions. I continue to want to know how the blue paint test was allowed into evidence, because they said it wasn't attempting to simulate what happened to John O'Keefe. They said that. So why are we discussing it? If we're gonna start bringing relevance into this discussion, man.
To impeach her, and to me, that had more of a, I guess if you wanted to use Mr. Brennan's words, more of something kind of maligning a witness. I just didn't see the relevance in it. Yet the judge declared that it was relevant, even though it had nothing to do with what happened at the nightclub in Rhode Island. It was a fire, it was a possible arson or negligence, but it really wasn't relevant. So you have this one witness, when you put these two together, you have this one witness by the defense who in my view, if it were me, I absolutely would have allowed them to cross-examine on that. It's on reliability, and it's on an issue that's not only relevant, it's almost exactly the issue in the case. It was related to phone data. So I was stunned by that. And I did post about that I thought it was a violation of Karen Reed's Sixth Amendment rights to confront witnesses and to elicit positive testimony. But as I talk about it and sort of preparing for this, what I wanted people to see is when you put it side by side, then you have to make a decision about whether or not you think it's fair when you look at, oh yes, this 20-year-old Rhode Island station fire can come in, which was interesting because even in that case, that she wasn't declared unreliable by any kind of a court. And not only that, there's almost a sense of, did the prosecution do its homework and find out the fact that in Rhode Island, like Massachusetts, medical examiners are not called to the scene of a death. And so it just made it even less reliable, yet it came in. And so I think you can understand why people see some unfairness, especially I think when you start to compare cases. And this happened, I don't know if you want to go on, this happened with Burgess too, which I also had an issue there.
Yeah.
Did you have an issue with Burgess? Really? Why would you have an issue with Burgess, Your Honor? Yep.
The comment makes complete sense. And from a lawyer's perspective, I appreciate these thoughts from a judge, because from a lawyer's perspective, one of the most important things I look for in a judge I like trying cases in front of is that they're consistent, to where if they're going to do something with one expert, we can expect it with all the experts. And I think that was one of the problems.
Right. This is what I talk about. Consistency is the thing, man, because judges like different things. As long as they are the same, then, different judges care about different things in different ways because they're human beings and they do. Like, for me, foundation is not as important. Like if I were a judge, like foundation, it's not as important as it would be to some judges, because I just want to kind of get to the point, right? I want to get to the point. So I'm like, I can blow through foundation a little bit because, it's like, just can we get to the point, please? Right? So foundation for me, not as important. But as long as I apply that both ways, then everyone understands the rule. It's like, oh, judge on civil foundation just isn't as important to judge on civil. Another thing, like scope on cross, like in jurisdictions that limit scope, I probably don't really care that much, which is not a particularly unusual trait. A lot of judges don't really mind. It's like, because they'll open it up because it's more efficient. So it's like, yeah, scope, it's fine. On cross, you can have scope. I don't care. But as long as you're consistent about it both ways, it's fine. It's just it is what it is. Yeah.
problems with Judge Cannoni throughout the entire process. And
also stop wasting my time. Stop it. Right. That's the other thing. Like, I want to bring the chess clock. That's one of the reasons like Foundation doesn't bother me, because like, just get to the point. Stop wasting my time. Less setup, more punchline. Yeah.
Pointed out one of the inconsistencies. Another one that I noticed is, one dog bite expert that seemed to have a lot of experience had to be voir dire multiple times, even after testifying in the first trial. Another dog bite expert, rubber stamped.
A voir dire of an expert after they've already testified in the same trial previously is a new one. That hadn't occurred to me. Yeah, that hadn't occurred to me. That's a new one. A voir dire of an expert in the second trial in the same case, when we already voir dire them once. We've had one voir dire, but how about a second voir dire? What? Why? Why? Didn't we already establish this? The case isn't completely new for every purpose. You do understand that, right? It's not, we don't have to completely reset everything to zero, right? You know that, even though it's a new trial, right? Not everything goes back to completely zero, right? We don't have to redo everything.
Come on down. You can testify. Didn't end up getting called. But what do you see with things like that? When you're a judge and you're making these decisions and everybody wants all these experts in, and of course, everybody's going to object to every expert. How do you deal with being consistent in making your rulings?
Yeah, I mean, you have to be consistent with the law. And so that's
would help.
how it is. I mean, you have to take the facts, as you know, the facts are always different.
Mm-hmm.
And so I used to say, when I would hear motions to suppress, are you telling me there's no Supreme Court case or Massachusetts case that hasn't addressed this one issue, this factual pattern? But the reality is there are so many factual patterns that you have to look at them differently. But what you have to do is apply the law consistently. So you look at this issue here with, for example, with Burgess.
Mm-hmm.
Okay, so you have a witness who's coming in, and one of the main aspects of declaring someone to be an expert, because anytime there's going to be a witness to testify, as soon as the voir dire is over, if there is a voir dire, and sometimes there isn't a voir dire, the prosecutor or the government, whether it's in a termination of parental rights case or whatever, will say, Judge, I'm asking you to declare this witness as an expert, but not just an expert in something.
Right.
So in my case, it would be, I'm asking you to declare this pediatrician as an expert in pediatrics. And then I would have to decide when they would say, and in child abuse, whether there was enough expertise in child abuse, or if it was a sexual abuse case, is this person an expert in sexual abuse? So every time there's an expert, not only does the judge have to declare the person an expert, but they have to declare exactly what they're an expert in. And so this is what you're seeing with these witnesses. So you have, let's say, Burgess, who comes in to testify. I don't think there was a voir dire, right? No voir dire.
There was not.
Burgess.
There was not, for some reason.
Because everybody knew ahead of time that his resume on the Aperture site, and I'm sure the Commonwealth knew it, didn't match what he was going to say. I mean, he changed his resume to say that his education was in progress.
Currently pending, if you don't mind.
To a court, so he was going to testify, and this information had been found out. But you're coming in with an expert witness who's already lied about something, and not only lied about something, but has lied about his resume. And, people are posting, he didn't lie about his resume. He said it was pending. Yes, he did at the trial, but he was declared, the reason that he was hired by Aperture was for his expertise and certifications, and for his resume, which said he had a bachelor's degree in two things, mathematics and business management. So, if I had an expert who was testifying in my court, and they were going to testify about a radiograph showing a fractured skull, and then I found out that the person was a medical doctor, but not a radiologist, but had put that they were a radiologist on their resume, I wouldn't even allow them to testify.
Are they a radiologist in progress?
Yeah, misrepresentation, it's a lie. And even though it's a bench trial and I'm making decisions, I would say to myself, I can't trust this person. This person already lied. So why am I going to hear this?
you're the gatekeeper of reliability as the judge. So if you find that somebody's not reliable, what we don't want is to allow people to go trick a jury, and somebody that's willing to lie or do things that is inappropriate that you have declared as the judge, as an expert, because the jury is not going to know that. Or if it's a bench trial, the judge, you have to consider that expert testimony if you let it in. So you're explaining the gatekeeper role perfectly. That just wasn't done in this case, I feel like, appropriately.
Yeah, I mean, I think with Burgess, I was very surprised. Very surprised. There was this whole notion that kept coming up during the trial, and I don't know if you heard it, but a lot of people posted about it, that when the defense would object to someone like Burgess or someone else, and the judge would allow it to come in and that case, without a voir dire, she would say, "I'll allow you to engage in a robust cross-examination."
Yeah, really
I was
robust.
actually stunned by that, because I would ask myself this question in my head: tell me, under what circumstances is someone not allowed to engage in a robust cross-examination?
That's a reasonable question, Your Honor. There's such a thing as a non-robust cross. Yeah, that's a good question. Yeah. I it's like, sometimes you have to be reminded of the basics. It's like, oh yeah, that's right. There's no such thing as a non-robust cross. That's right. Oh yeah, that's how stupid it is. Oh yeah.
Examination. So it comes.
Exactly
it came across,
exactly what I said.
I mean, sort of came across like, well, I'm going to give you this opportunity because I'm allowing the prosecution to bring this guy in whose resume, as of this day, on Aperture is a lie. And not only that, I'm going to allow him to testify. And by the way, I'm going to allow him, even though he has no bachelor's degree in anything, but not only am I going to allow him to testify based on his accident reconstruction certifications, I'm going to let him testify that as to the cause of injuries to John O'Keefe.
Yeah, that sounds problematic. You were stunned, Your Honor? You were stunned? It's nice to know we're not alone. It's nice to know we're not alone over here. It's like, have we all been taking crazy pills? Right? Like, have we all been taking crazy pills? Oh no, we're not alone. This ain't right. Yeah, okay.
But it's her decision. But when you compare it for consistency,
is it though?
Then you have Dr. Russell and Dr. Leposada, and she's of course allowing them to testify. I mean, there was no question. I mean, it's one of the few things I think I talked about on Court TV that I had never seen or heard of a witness that was so qualified as Dr. Russell. Both of them incredibly qualified, and so. First, the judge allows the nightclub Rhode Island thing, which, in my view, if it were my court, I would have viewed that as irrelevant. But then it's like, well, I'm going to allow them to testify, but I'm not going to allow Dr. Russell, who's like the dog expert of the century, in my view, but I'm not going to let her say it was a dog bite, but I'll let her say it was an animal bite. Yeah. And so then there are these limitations. And yet I'm comparing that, where, you have someone who can say that those injuries on the arm are from a dog bite. No, I'm not going to allow it. And then there were some limitations on as well. Limitations were put on Dr. Leposada, and yet no limitations are put on this witness who has no resume that shows an expertise in anything related to injuries, and he's allowed to testify. As you know, they call it the ultimate issue. The penultimate issue is guilty or not guilty, but the ultimate issue, which was, was there a collision, and was John O'Keefe, hit by a car? I don't comment on the evidence. I left that, as everybody knows, any post that I made, I said, this is up to the jury. I'm never going to comment, even though people ask me, do you think guilty or not guilty? But the notion that those experts, Dr. Welcher and Mr. Burgess, could actually give an opinion as to what caused the injuries, that the ultimate injuries were caused on John O'Keefe, that's one of the ultimate issues. Yet you have these two doctors who did a great job, and it came across, in terms of what the ultimate issue was. But when you compare the two side by side, you have to ask, was it consistency? Was it fair? Or as you
again, like some experts can testify as the ultimate issue and some can't because they're not qualified, I guess, or something. If Burgess is qualified, how is anyone not qualified? It's the consistency, right? That's the problem, right? It's like pick one or the other. Pick one or the other, not both at the same time. Again, like in terms of temperament, I imagine that I'd be a little bit on the higher end for an expert witness. So like on the bell curve, I'd probably be a little bit stricter. I don't think I'd necessarily be the most strict, but I think I'd be a little stricter as a judge on expert witnesses compared to a typical judge. I just think. So like not as strict on foundation, not as strict on scope, a little stricter perhaps than your average jurist on, expert witnesses, but like just pick a lane and apply it across the board, man. You know what I mean?
you say, was it consistent across the board, consistent with the law? And that's the way I looked at it.
Yeah, and when you come to making these decisions and you're trying to be consistent and you're looking at it, and regardless of what you and I can say about Dr. Russell and La Posada, it seems so very obvious. Some people that maybe haven't seen a lot of trials, haven't searched for experts, haven't interviewed and hired experts, haven't declared people experts like you have. Maybe it's not as obvious to them how different these experts are and how top echelon these experts are, but it seems so obvious to those of us that have done this for a living and are still doing this for a living. Not only did Judge Cannoni rubber stamp the less qualified experts and require voir dire of the more qualified experts, but she also went further. And you've written orders before. And in your orders, have you ever used the language Judge Cannoni used to say, this is a close call, and here are 5 issues that the Commonwealth could use to cross-examine Dr. Russell, where I think she's pretty weak? Have you ever done things like that in an order?
I was stunned by that. No, I've never done anything like that. And the fact is, the reasoning behind it being close, it was just amazing to me. And again,
close my ass.
I mean, was it even close?
That's what I said.
Qualified when his resume on our.
Well, I think I'm ready to be a Massachusetts judge, guys. I mean, apparently I understand the law pretty well. I mean, put me in, coach. I mean, this judge is telling me I have all the right answers. Thanks, Judge. Put me in. I'm ready to go. Damn.
Picture was a lie. I mean, it's absolutely stunning. But did you even have a voir dire? No. What you had was, again, a robust cross-examination, which is allowed for the defense to do on every witness. And that was sort of the excuse. Well, I'm going to allow a robust cross-examination. I'm thinking to myself, what does that mean? Like, that's not something that I could picture myself saying, because every defense person is allowed.
I don't know if I could be a trial judge or not, though. I think I get frustrated with the minutia after a while. The thing about trial judges, because they are so deep in the minutia of the case, because they're the first ones that see the case, right? So they kind of see everything, right? Because the Court of Appeals are much more focused. So Court of Appeals are much more focused on a much more smaller thing. Trial judges are focused on everything. I think the minutia would get to me after a while. With all the pettiness and bullshit. I don't know if I'm necessarily the best trial judge. I think I'd be a great Court of Appeals judge. I don't know about trial judge, though. I think my frustration would run out with both sides after a while. I hate everybody.
Cross-examination.
It's not one of the Yeah, it's not one of the listed remedies. A listed remedy is you strike the witness, you limit the witness, you sanction somebody. Like, those are the remedies that are available to judges if they find somebody lied or did something wrong. It's not, no listed remedy is I'm going to allow you to cross him really good. You can go, you can go hard on cross. Like,
and you said it, I think, kind of the right way. I think, I'm trying to be judicious about the way I say things, but but of course, I think you're right. I mean, I
want to bring the chess clock into it. That's the only way I can preserve my sanity. I think I need to figure out a way to make chess clock legal in a criminal case or whatever. I don't know. That's what I need. I need chess clock. I need to figure out a way as a judge to make it legal. It's the only way to preserve my sanity.
I just couldn't find that. When I read that decision and it said this was a close one, I was shaking my head and thinking, how is this even close? This is a woman that has 30 years of experience. She's written articles about dog bites. She's probably seen 1,000 dog bites as an emergency room physician. She worked with a police department. I mean, her credentials were impeccable. I mean, impeccable. And so, again, I all I can say is how I viewed it. I mean, how the judge viewed it. That's her discretion, just like every other.
Yeah, but this judge, of course, understands, but she's not going to say it out loud. When she says discretion, she, of course, understands there's such a concept as abuse of discretion. Saying discretion implies the judge is correct. If the judge is within their discretion, then they can do it by nature because they're within their discretion. They have discretion, but there are limits. Would you like to opine as to whether or not this judge went outside? Did she color outside the lines? I think she might have colored outside the lines a little bit, Your Honor. Would you be so kind as to say it out loud?
The judge has discretion. She can view it any way she wants. So I'm not going to criticize the fact that, she exercised her discretion. That's what we expect judges to do. Just from my standpoint, I just didn't see it that way. I didn't see that it was even close. And then this sort of going on in the decision. But, the defense, the defense could do this and can do that. Sort of, it was almost like instructing the defense on how to approach this and maybe, in a way that, wasn't so overt, but I mean, that was just a feeling I have. I'm not accusing the judge of anything, of course, because she has a right to make the decision any way she wants, but it just seemed like there was a lot of guidance provided there. That's just not something I would have done. I just would have decided. I mean, in that case, from my view, and I've spoken about this very issue publicly before, I mean, she was probably one of the most qualified witnesses that I had ever seen. And so to put restrictions and limitations on the testimony was just not something I personally agreed with. Other judges might disagree with me.
Yeah, and that's the beauty of judicial discretion, which I try to explain it to people as best as I can, but it's really like mom. It's like mom's going to make her decision. She might not always be right, but it is mom's decision to make in most circumstances.
In most circumstances,
right? You may disagree, but it's her decision to make.
Yeah, but again, like, you can go beyond the pale, or beyond the pale's too hard, but you can go outside the bounds and abuse it, especially if you're doing it in an uneven way. Right? So judges get some latitude. They get a fair amount of latitude to be all things considered, but it's not infinite latitude. And discretion is good. Discretion is good because cases are complicated and we need some flexibility to deal with, the dynamics of the thing and the human factor, which is also non-trivial. But there are limits. Would you like to opine about those limits?
Additionally, to talk more about the judge's comments and what comments you may make, Judge Cannoni intentionally and purposefully decided to make comments on the record about attorneys throughout this process, specifically having grave concern about certain things the defense attorneys did, finding that they violated Rule 14. You know, these things that she said about Attorney Jackson and specifically the defense attorneys, I'll just say it because she didn't really do it to the prosecutor at all. Those things can follow an attorney. And lawyers can then cite that if they write a motion to you and say, hey, Tragos over here in, Idaho, this judge said it. You don't know who that judge is in Idaho. You have a record of a judge saying you're not reliable or you violated this intentionally. Talk about how big of a deal that is to you as a judge to put something like that on a record about a lawyer and how careful you would be to do that.
Well, I'm glad you brought that up. That was a huge, huge deal for me. And I think I might have commented about it, but I didn't want to, get people all fired up about it. But I will say I was fired up about it because when you're on the bench, you have to be so careful about what you say. And you always have to remember that there are rules about what judges can do and not do and what they can say and not say. And judges cannot say things that, bring about any kind of view that they might be biased. When I posted about it, I called it the grave concerns shot heard around the world, and that's sort of was my description, and that's how I wrote it, because in my view, in terms of judicial discretion and the proper way you have to carry yourself on a bench, to me that was improper. And the reason I say that is, first of all, it didn't have to be public, because it was surrounding a potential violation. So that's when you bring judges back into the lobby and you sit down with them and say, we need to discuss these improprieties, because that's not really related to the evidence in the case. And so if you think there's some impropriety, you can report it to the Board of Bar Overseers. You can report it to the outside agencies. But to put it out there in front of essentially millions of people, and it also was the way that it was said, I have grave concerns. And you'll notice that she got off the bench shortly after this, which maybe it was a recognition of, maybe I shouldn't have said it that way. And this sort of, degrading comments maybe about the lawyers and in particular Jackson. I think her feelings of I don't know what to call it, animus or whatever towards Jackson came out at times during the trial. At least I felt that way. Maybe other people disagree with me. However, that I think was improper. And I can't even imagine myself being on the bench and saying something like that, because like you say, something like that can follow. And a lot of what was being said at that time hadn't been investigated, hadn't been vetted. So you have this comment that's coming out prematurely that's, just has this, effect, this very negative effect coming out that millions of people are hearing. I thought it was improper, and it's kind of set a tone, and it also said something. It causes you to ask the question: is this judge a neutral arbitrator if she's saying something like that? And that's what has to happen, because until you are making a decision on something, you have to be a neutral person and listen to the evidence. So I was, it's hard to criticize another judge, and I've been criticizing, judges at times in cases that I felt did not show, maybe proper judicial, the proper judicial manner, or whatever you want to call it. But I have to say, this was something that really I was taken aback by. I just couldn't believe it. And you're right, I didn't think of it in that term. Exactly what you pointed out. This is something that other people can use later on. Just having someone just make a declaration like that. And the reason I called it, the way that I did was because it was heard by everybody. Every newspaper published it. It just I termed it as the sort of the shot heard around the world, and in my view, this is something that violates the very constitutional tenet of the Sixth Amendment rights. A lot of times I focused on that. I teach constitutional law, so I have a heavy focus on it. And a lot of my viewpoints were premised in that.
Yeah, you might not be able to believe this, but I've been criticized too for reacting to what lawyers and judges do and say, and try to say might be how I see it or how I do it differently. You opened up saying every single time there's going to be a lawyer that walks out of the courtroom disagreeing with the judge. That's not a surprise. That's how it is. And I think as long as you do it in a respectful and gracious way, which I think you've been more than that throughout this process, this is the only way for people to learn. I don't want everybody in this chat, everybody in Massachusetts, to walk away from this case thinking every judge is like that and that every judge acts like that or sees it the same, or because people are going to, one of the points of this channel is to not be afraid of our judicial system, but to understand it and to walk in and understand what should be happening. What are your rights? What is a lawyer there for? What is a judge there for? And I think you've done a great job of explaining and defining so much of what a judge is supposed to weigh and listen and do throughout the process. And when you talk about maybe it feels like a judge has a lean one way or the other, or loathes a certain attorney, so many people have asked questions about, 49 out of 49 objections sustained from the Commonwealth and overruled from the defense, 50% or whatever it is. Did you ever keep track or feel, because we just got done with the NBA finals, one team sometimes has a lot more free throws than the other team. Sometimes it just happens, but have you ever felt in a trial that, one lawyer was just doing a better job at objecting and that's why they won? Or, have you ever felt yourself in that kind of a situation where it felt like you were sustaining every objection from one lawyer and overruling every one from another?
Well, I think, yes, we're always in that situation. A lot of it has to do with the competencies of the lawyers.
Exactly.
I mean, there are times when I'm sitting there on the bench thinking, I cannot believe he's not objecting to that.
Yes.
Or, and you're thinking to yourself, oh my gosh, how much more hearsay can I listen to without someone objecting? Because, I think probably one of the most important things you can do as a lawyer, and something that was so important to me, was just sort of keeping up with the rules about hearsay and objections and what they are and when they're proper. And as a judge, every year they put out a book in Massachusetts on rules of evidence, talking about the most recent cases. And that's just something I read from cover to cover.
It's probably be a good idea, like if you're a judge, and they produce a little book that says like, hey, here are like the updates in law, just so like you're aware of it. Probably reading the book sounds like a pretty good idea to me. Just so that maybe it's somewhere in the back of your head. It'd be like, oh, didn't I remember reading something somewhere once? Maybe because it's like I could go look for that, all right? So maybe you should read the book. The reading the book is good. All right. Good news, or at least update news on my watch. The watch progress continues. I have now successfully paid import duties on my watch. Exciting, apparently. So my watch is somewhere between Kentucky and here, and having paid the import duties should arrive well, maybe today. I don't know. I'm not sure where it is right now physically. It's a little unclear from the UPS tracking site. I'm not sure if it's still in Kentucky or if it's somewhere between. Yeah. So I'm not sure if I'm getting it today or tomorrow, but it should be happening soon. I am hyped. I am modestly hyped. So I'm excited about that. And then we'll have an unboxing and we'll compare it to the watch I currently have, which looks exactly the same, but is 10 times more expensive. And we'll try to decide. We'll try to decide whether spending 10 times as much money for another watch that looks exactly the same was a good idea or a bad idea. Actually, it's a little bit worse than 10 times now. It's more like 13 or 14 times. Yeah, it's going bad. Lord have mercy. All right. Okay, that's fine. I'm still getting a good deal on it.
Year, so I would know, if there were any changes and how to react to objections. I think, a lot of it depends on really how seasoned maybe a lawyer is or how much they're in evidence. But I will say, related to this case, I mean, it's really hard when you've been a judge and you're hearing people objecting on a huge case like this, and you're thinking to yourself, just no. So one thing people have asked me a lot about is why didn't during the trial people say objection, hearsay, or objection?
That's what I want to know.
Glad you're here.
I want to know that.
Loads of people ask me that. Well, you know, the reason, I mean, in every case where there wasn't a jury, if it was a non-jury trial where I was hearing the case, or if it was a child abuse and neglect case, in every single trial, you know, I would say to the lawyers, what's your objection? What's your objection? And sometimes, it would be what I used to call the I don't like it objection, you know, where they couldn't point to, you know, it's hearsay, you know, it's irrelevant. It calls for, you know, a conclusion without a foundation, and you know, so it's you know, you just are asking people what's your objection. But in a jury trial, the issue that comes up there is you're asking people who don't have any connection to law whatsoever to sort of understand things and then draw some conclusions from it.
The taxes on the watches, the tax is a killer.
So when you're objecting and someone objects,
too many taxes,
and says objection, what's your objection? Facts not in evidence. Then juries are going to make conclusions about what that means without really understanding exactly what that means. And so in jury trials, one of the reasons, and I think it probably caused so much aggravation for people, like every 5 minutes, you know, the lawyers are going up to sidebar, right, and talking to the judge when there's an objection. And basically what they're doing at that moment is they're putting on the record what their objection is. Look, this is, you know, speculation, there's no foundation laid, and they're doing that to preserve the record for appeal. But they're not going to do it with a jury trial because you don't want to confuse the jury with what some of those terms mean. It's an improper hypothetical. Well, I mean, you know, how are you going to explain what that means? You know, it's a hypothetical that was created, but there weren't facts and evidence, which is a basic requirement for a hypothetical. So they go up to sidebar and they say, we want to put our objection on the record. You're allowing this hypothetical to come in, judge, and the you know, the prosecutor or the defense attorney is using facts that aren't in evidence. So that's what's happening a lot of times at sidebar, and why you're not hearing. But what's problematic about that is at the time, as Alan Jackson, I don't know if you heard his interview, but a very brief interview he did on Boston radio afterwards, and saying, you know, that there had been, I think, 49 objections, and they were all sustained. You know, objection sustained, objection sustained. A lot of people heard Judge Cannoni say this to the lawyers, ask it another way. I'm like, I don't know if the lawyers knew what that meant, but I have to tell you, I didn't know what that meant.
It's just nice to know I'm not alone. It's just nice to know that I'm not the one taking crazy pills. It's nice to know I'm not alone. Yeah. Wasn't quite sure what that meant either. Yeah, why aren't we stating the basis for objection? Also, what does ask another way mean? Yeah.
Assume that it meant, as you would know as a lawyer, objection maybe calls for facts not in evidence, or it's a compound question, and so sometimes you have to ask it a different way. Or objection, it's leading the witness. If you're asking a question, if it's your witness, you have to ask, as you know, a direct question. You know, what's your name? What did you do next? And then what did you do? You just testified that the car ran into a tree. What did you do after that? You can't say, And after the car hit a tree, isn't it true that the driver came out and said it was his fault? You can't lead a witness except on cross-examination. And so that happened a lot in this trial. I mean, those rules were broken tons of times, but there's only so many times that you can object without, I think, annoying the jury.
True.
And so, I think they're very careful, and I'm sure, as you know. So, all these 40 some odd objections, I'm listening to it and I'm thinking, geez, I was a judge for, 20 years. I heard, thousands and thousands of objections, and I'm hearing this judge say, ask it another way. And I don't know what that means. And so, the judge can say things like, the objection is sustained, rephrase the question or something like that. But I just didn't understand this whole concept of objection, sustained, ask it another way. There were times that Alan Jackson complained, he once said, sometimes I had to ask it 17 different ways, because there's no guidance from the judge as to what's wrong. And so, and I couldn't even as a judge for years at times tell what was wrong with the question. In other words,
I feel all this.
What evidentiary rule it broke. And so it was frustrating for me to hear that. And it was clearly frustrating for Alan Jackson. And so then, you have people, online and on X saying, they're being unfair. But, what is concerning is there was a lot of evidence that he was asking about that was just,
would you email me?
Sustained, without any objection, and then just looking and saying, ask it another way without any guidance.
Sub Rosa, you mailed me your KR season 2 in 1A4. What'd you send me? What is this? At the beginning of the second trial, I used scribbing as anger management theory during Brandon's droning. Seeing as there's a great season finale, we'll soon move on to shiny new shenanigans. I thought I'd share with you just for fun. P.S. There's a general vibe, to be honest, all that good stuff that had to come in. Okay. This is interesting. All right, let me put this on screen for a second. This is kind of interesting. Hold on. Talk amongst yourselves. Is it not going to let me do this? Come on, don't be mean. All right, we'll do it this way. Will this work? Yeah, all right, this is cool. Apparently this is some random scribbing someone did. Just your friendly neighborhood lawyer. There was no collision. And then equations. She hit him. I'll allow it. We, the jury. Free me. This is a lot, man. This is very, very cool. Very, very nice piece of art. Very, very cool. Very nice. Thank you for sharing. Appreciate it. And it's made on A4 paper. Not that means you're a European. It's not that 8.5 by 11 that we use over here, which is almost A4. It's really close to being A4, but it's not. Because we've got to be different, right? We've got to be different in the United States. Can't use A4 like everyone else. Let's make it 8.5 by 11. It's almost the same as A4. We're a strange country sometimes. What are you going to do?
What the issue is. In other words, saying it's a compound question. They were asking two things, or whatever the issue was. And so, from that standpoint, it had a very unfair quality to it, and clearly, he was quite clear in being upset about the way that was handled. Just in his sort of cynicism, which you can understand, saying, I had to ask it 17 different ways. I just didn't understand what the legal basis or the evidentiary basis was for all those objections. I mean, to me, it's unheard of that someone can object, that the district attorney.
And then theoretically, there's this thing called legal paper, which I've never used ever. Right? Because some of you guys might know there's this size called legal. It's 8.5 by 14. I have never used legal ever. I don't know what it's for. Anyways, we got a new subscription from Cindy. Thank you, Cindy, for subscribing to us on Ko-fi. No one uses legal. Why does it exist? I don't know.
ADA prosecutor objected 49 times, and that it was sustained 49 times, really without any explanation other than to say, ask it a different way. I mean, that's not my view of how that should have gone. Again.
Oh yeah, and then of course the Supreme Court, just to be different, has a unique size just for them, which I have to look up every single time, because that's the Supreme Court wants to be really different. Yeah, the Supreme Court has bullshit paper sizes. It's like 6 1/4 by 7 3/8 or some bullshit size that only they use and only they have ever heard of, which of course makes printing really complicated because no one makes the paper, because no one uses it except for the Supreme Court, because they want to be special children.
It's just my view.
I mean, I don't know any judge that would say, yeah, you should say, I'll allow it or ask it another way. But there's just such a big difference as a lawyer if I'm questioning a witness and you just say sustained versus if you say sustained leading or sustained compound. I know I can still ask this question. I can rephrase it. If it's sustained hearsay, I'll ask it a different way, right? That's how you can ask it a different way. If it's sustained relevance, then I can't get into that subject. Like, the reason for the objection and the reason for the judge's decision leads the lawyer to know, what can I do next? Because I want to get this information out. And if you just say sustained or ask it another way, then what happens? 15 different ways I'm going to try to answer that. And that's why I kept feeling
6 1/8 by 9 1/4. Yeah, I told you it was something stupid.
So many different ways.
6 1/8 by 9 1/4.
Judge controlling.
Yeah, it's pretty stupid, isn't it?
There are a couple things I have to ask.
Who uses
Everybody
this?
Wants to know. And you said you wanted to talk about this anyways, right before we started. So I think it's just perfect because the chat's in the same wavelength as us. Let me bring up a couple of these different ways they asked it. So we have, can we ask about excluding Easter? I have a couple questions. Canoni keeping out Easter was reprehensible.
You use legal in housing?
Sixth Amendment right. Easter.
Okay. All right, there you go.
There's a bunch of these. I'm going to.
All right, so someone out there is still using legal.
Thoughts?
All right, fair enough.
And then there was a couple questions about. I'm behind, but what about keeping the police investigation expert out? I'll continue to throw questions about Michael Easter up. What were your thoughts? I think you said you may have caught or you heard that I interviewed Michael Easter yesterday. What were your thoughts on his testimony? Why Judge Canoni maybe would have kept it out, and what you thought about that?
Well, it's really, and it's something that, I had made a comment about and watched his interview, his excellent interview yesterday. I mean, the issue about having an expert comment on the investigation is generally viewed as something that's not admissible because they want the jury to make that decision. And so it's considered a function of the jury rather than having someone say, this investigation went wrong. They want the jury to listen to all the facts about the investigation. And so there aren't that many exceptions to that in either under federal law or under state law. But the exceptions that exist have basically to do with in terms of whether or not you can criticize police and criticize the investigation, have to do with whether or not you're asking that person is an expert to comment on things like the evidence or forensic analysis, not so much on the police, but in how the investigation was conducted. And, things like forensics or evidence, if that's an issue in the trial. And so I don't think there's ever been a case where how the investigation was conducted, how evidence was compiled, including forensic evidence, and where this was sort of an alternative
we know where this is going.
hypothesis in the trial. I don't think there's ever been a case where those factors applied. So there are circumstances where someone can testify about the investigation, even though it's discouraged and even though it's generally not allowed, but allowed in certain cases. And so in my view, it certainly, there never was a case that fit the criteria for where it can be allowed, because the case rested on an investigation that took place in front of the house, where evidence was collected in solo cups, where there was
the solo cups, red solo cup.
Could see.
I fill you up.
Wasn't collected.
Let's have a party. Let's have a party.
And
red solo cup.
Issues regarding.
I fill you up.
Evidence. So, in my view,
let's have a party.
I think, Easter's testimony.
Let's have a party
under that narrow exception, because that was one of the main premise. That was a main premise of the case. And so, from my standpoint, they could have limited his testimony. The judge could have limited it to that. But I think, and again, I hate to keep bringing up that pesky Sixth Amendment right, but who has the rights here? The person that has the rights is Karen Reed. And so to say she can't have this witness, and the judge had, cited case law, but in this particular case, I think it's allowed if it ties, sort of directly to the forensics and the analysis. And they, in this case, they sort of had this third-party culprit kind of defense. So to me, there was enough connection that they should have allowed Easter to testify, even if his testimony was narrowly limited to those areas regarding the collection of forensic evidence and normal police processes. So I guess that's my answer. I think he should have been allowed to testify on balance. As the Commonwealth often said during this trial, that they too have a right to a fair trial. But when you balance their right to present a fair trial with the Sixth Amendment right of Karen Reed, it's a whole different factor, because those rights supersede anyone's rights in this case. And so in order to be fair, I think they could have allowed Easter to testify under a narrow exception based on the premise of the defense's case.
All right, guys, I'm going to go ahead and end it there. I'm a little tired. I've been streaming for 4 hours. I'm actually a lot tired. I'm gonna take a little break here. I'm gonna make it to the gym today. It's about to rain, so I'll probably wait till the rain ends and go after the rain ends. But I need to go. I need to sign off because I've been streaming 4 hours and I'm tired. These long streams, man, they get to me. But it looks like I'll have my watch tomorrow, and we'll do an unboxing tomorrow and try to determine how it worked, and we'll see how it went. So we'll see. All right, guys, I'm going to go ahead and sign off. I've been Uncivil Law. Till later, my friends. I hope all is well. Cheers for now, my friends, and goodbye.